For reasons mentioned in the order, this court finds no merit in the revision petition and accordingly same is dismissed.
May it please the Lordship. My lord, with the consent of appellant, my lord, I beg to mention item number 12.
Yes.
Yes, I am appearing on behalf of respondent, my lord, S.H. Chaudhary representing the respondent. Appellant is also here, my lord, only seeking a 2 weeks time, my lord.
Mr. M.A. Chaudhary, learned counsel for the respondent, who prays for an adjournment on the difficulty of conducting counsel for the respondent, Mrs. S.A. Chaudhary. Learned Mr.
G.R. Datta.
G.R. Datta, learned counsel for the appellant, does not opposes the prayer, hence the prayer is allowed.
Your Lordship, if any fixed date may be.
No fixed date. Let this matter be listed after 2 weeks.
2 weeks. I'm DQ of that.
With regards to item number 13, Lordship.
13.
1-3, Lordship. I'm praying that the matter may be taken after a week, Lordship. We are filing today an affidavit, Lordship, to bring on record certain documents.
Heard Mr.
A. Dhanuka.
A. Dhanuka, learned counsel for the appellant, who prays for some time to bring on record certain documents by filing an additional affidavit. The prayer is allowed. Let this matter be listed after a week.
May I please, Your Lordship? I beg to mention item number 49, Lordship, hearing this, Lordship. For hearing. And if you wait for adjournment for the day, Lordship, we taken consent of the other side, Lordship.
Heard Mr. P. Bora,
Yes.
learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty. Also heard Mr. N. Alam, learned counsel for respondent, who does not opposes the prayer. Hence the prayer is allowed. Let this matter be listed after 2 weeks.
Can we post it on 28?
Fixed date, it is difficult. Let the registry fix the date. Which week you want?
20 of August.
Let this matter be listed in the last week of August on a date to be fixed by registry.
Obliged, Lordship.
My lord, item number 6 may kindly be taken up after motion because Cabinet Council, Mr. Mohanta will go to Hyderabad. This will be updated, my lord. Item number 6. Just after motion may kindly be taken up, my lord.
Okay.
He will go to Hyderabad.
Okay, allowed.
May it please, Lordship. Lordship, I beg to mention item number 30. My lord, I have instruction not to pursue the matter, my lord.
Item number,
30.
you are withdrawing.
Yes, ma'am. There is an IA also for implement of the appeal, my lord, along with the IA in the second appeal, my lord.
Heard Mr.
P. Bora.
P. Bora, learned counsel for the appellant, who prays that, who submits that he has an instruction. He has been instructed by the appellant not to pursue with the present appeal and therefore prays for allowing the appellant to withdraw the instant appeal. The prayer is allowed. This appeal is dismissed on withdrawal.
Deeply obliged.
May I please, Lordship? With the consent of the other side, Lordship, I beg to mention item number 5, Lordship. Any matter may be adjourned after 2 weeks, Lordship.
Third, Mr.
A. Hussain.
A. Hussain, learned counsel for the petitioner, who prays for an adjournment on ground of personal difficulty. He submits that he has informed learned counsel. Also, Mr. R. Fukon, learned counsel for the respondent, who does not opposes the prayer. Hence, the prayer is allowed. Let this matter be listed after 2 weeks
So I'm praying for a date, Lord.
on a date to be fixed by registry.
Lordship. Obliged. May it please your lordship. Lordship, I beg to mention item number 35, lordship. Lordship, here in this case, we were instructed to take steps, lordship, but we took steps only on 14th August. So some time may be granted, lordship.
To take fresh steps.
We have taken the steps, but on 14th August.
14th August, which date? You have taken steps for issuance of notice to respondent.
Yes, all the respondents.
Which date respondent will appear? What is the returnable date mentioned?
Returnable date was 4 weeks, lordship.
4 weeks.
4 weeks,
It was from the date when the order was passed.
lord.
You take fresh steps.
We just took fresh steps, lordship. But some time may be granted so that the.
Heard Mr. S.P. Sharma, learned counsel for the appellant, who submits that though the appellant was directed to take steps for issuance of notice to the respondent by returnable after 4 weeks, they could take step only on 14th of August, and therefore he prays for fixing this matter after 4 weeks. The prayer is allowed. Let this matter be listed after 4 weeks.
Deeply obliged.
May I please, lordship? Lordship, I beg to mention item number 46. Lordship, with the consent of other side, matter may pass over for the day.
Heard Mr.
A alone.
A. Alam, learned counsel for the respondent. You have informed the counsel for the
Not sick.
petition, who prays for an adjournment on the ground of personal difficulty. He also submits that he has informed learned counsel for the petitioner regarding his prayer for adjournment. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after 2 weeks
Lordship, there is an interim.
on a date to be fixed by registry. The interim shall continue till next day.
Deeply obliged.
I beg to mention item number 10, lordship. It is for admission hearing. There are some new development arising as regards the suppleant lordship. So that's why we get some information from the collect from the client.
Heard Miss
B. Locker
B.
on
Locker,
behalf of PS Deca.
B. Locker, submitting on behalf of Mr. P.S. Dekar, learned counsel for the appellant, who submits that in view of certain new developments in this appeal, the counsel for the appellant intends to seek further instructions from the appellant, and for which some time is prayed for. The prayer is allowed. Let this matter be listed after 4 weeks. 4 weeks on a date to be fixed by registry.
Item number 1.
Lordship, may I please? Lordship, the item may be passable for time being. My senior is unfortunately stuck in a traffic jam. There's a big traffic in there.
Okay, let him come. After some time.
May I please your lordship? Lordship, I beg to mention for listing of an IA in connection with an anticipatory bail matter which has been disposed of by your lordship. Lordship, actually,
When? There is some error in the order,
no, there is no error, lordship.
then
Lordship, actually, there was a condition that the petitioner has to take prior permission from the IO to go out from the jurisdiction, lordship. He has submitted his application for visiting his father who is very sick and who resides at Bihar, lordship. However, the IO rejected that prayer, and lordship, I have filed that IA for considering that prayer, lordship. On the previous occasion also, I have.
when you want it to be listed,
Lordship, today, lordship.
you have furnished the copies to,
Yes, yes, I have already furnished. It was filed on 12/8/2024, lordship, on Monday. However, due to some. Lordship as a last item also, lordship.
at 4 p.m. today.
Much obliged, lordship, much obliged.
Maybe. Lord, that the impugned order that your lordship will find
at page, my lord, 74. And my lord, operative part, lordship will find, page 75.
What? What is the matter?
Regarding my lord, amendment, petition filed by the my lord plaintiff, her respondent, for amending the plan, my lord, in the schedule of the properties. As per their amendment, my lord, the number should be 375 instead of 275.
Okay.
And the boundary also, southern boundary also, as it should be Moniruzzaman instead of Manju Ahmed. This is their pleading.
Whether written statement has been filed.
Written statement has been filed.
After filing written statement, they have,
Yes, they have filed.
okay, we are issuing notice.
And interestingly, my lord, the power of attorney, which has been given by the petitioner dependent, that has been revoked subsequently.
Let us issue notice. Heard, Mr. What is your name?
M.U. Mondal.
M.U. Mandal, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioners, namely Mojibur Rahman and Bonzo Ahmed, impugning the order dated 19/9/2023, passed in Mirja case number 90/2022, arising out of title suit number 5/2021 by the Court of Learned Civil Justice Senior Division Dhubri. Issue notice to the respondent. The petitioner shall take steps for issuance of notice to the respondent by registered post with heading as well as by usual mode within whether amended plaint has been filed. Amended plaint has been filed by the respondent in pursuant to this.
That instruction ought to be.
What is the date fixed for
Yes,
next?
I'll take the latest instruction.
Okay. Within 3 days from the date of this order, returnable on 24th of September. List accordingly.
But till then, the input order.
No. You are not aware of the status of the title suit. So on next date, that will be considered.
Applies.
Please, your lordship. Lordship, here I am appearing as a legal counsel of this matter, my lord. This is 24 application, my lord, filed by petitioners being transfer of the proceeding. My lord, we have preferred this revision, my lord, against the order passed by the learned civil judge without even considering the prayer for ad interim injunction, my lord. The impugn order is at page number 74. If your lordship may kindly see page number 55. Page number 55.
Yes.
A decision was taken by the Union Cabinet to set up a
center for perishable cargo in the premises of the Guwahati Airport. On a land
Perishable cargo.
cargo, perishable cargo means my lord, the cargo which are of perishable nature, like food, vegetables, that kind of cargo. My lord. So that center was to be set up over a plot of land measuring 4,050 square meters. So in pursuance of that cabinet decision, the AIDC entered into a lease agreement with the,
Who are you?
I am the Assam Industrial Development Corporation, AIDC.
Okay.
We entered into a lease agreement with the Airport Authority of India. The lease agreement is at page number 59. Lordship may kindly see the lease agreement at page number 59. It was executed on 31st May 2017.
Yes.
And if your lordship may kindly turn up to the next page, page number 60. It shows that the lease was to commence from 31/5/2017 and was to remain valid for a period of 7 years. And it expired on 30 May 2024 for a period of 7 years. And the rate was fixed at ₹1 as a token per year. On the basis of this lease agreement, we set up this center for perishable cargo in the premises in this scheduled land, investing huge sum of money amounting to around 15 to 20 crores. Now, just before this lease agreement was to expire, we wrote to the AI. My lord, and also kindly see page number 61, clause 7. Clause 7. It says that after expiry of 7 years period, the allotment will be made afresh as per AI policy involved. So there was also a stipulation that after expiry of the 7 years, fresh allotment will be made again. So just before the lease agreement was to expire, we wrote
Which clause? You are
clause 7, page 61, Roman 7.
Roman 7.
Yes, after expiry of 7 years period, the allotment will be made afresh as per AI policy involved. So there was already a stipulation that after the expiry of 7 years and the allotment will again be made afresh in favor of the AIDC.
That is not mentioned that it will
Yes,
be.
but
What is the policy in vogue?
yes, policy involved will mean the policy at
Which is
present
existing that
at
at that
particular
point of
period.
time.
Yes. Now, we made a huge investment. Thereafter, my lord, before expiry of this period, 7 years, we wrote to the AI to extend the lease period to another 7 years. That is at my lord, page number 64. Last line, the validity period of the said lease agreement was commenced from 31/5/2017 to 31/5/2024, subject to make afresh after expiry of 7 years as per AI policy involved. Now, what they did was that they sent us a legal notice. The legal notice is at page number 66. And the relevant paragraph is at page number 67, saying that we had violated the terms and condition of the lease agreement. Para number 5. If your lordship will kindly see page 67, para number 5, that recently it has come to the knowledge of my client that AIDC has leased out the said CPC facility to MS Guwahati International Airport Limited. That is the organization which is currently running the airport for a period of 15 years with effect from 9/5/2023 without prior consent of AAI, who has further subleased to MS Blue Dart Limited. This is a violation of agreement executed between AAI and AIDC. Furthermore, the part of land where the CPC facility is established is not a part of leased land and the ownership of the land is with AAI. Any entity on the said land without AAI consent is an unauthorized occupation. Accordingly, my client so-and-so requested you to hand over the land back to my client at once as subleasing of land is legally not permitted. My lord, the thing is that now if your lordship may again come back to the lease agreement at page number 61. Page number 61. The first line. Already there was a provision that the day-to-day operations can be run through a third party, a different contractor. That is there, my lord. First line, 50% of the revenue received through a revenue contract by the state government, state PSU in case of operating the cargo terminal through contract, that is appointing operation and management contractor. So we had initially given these running the operation to a subsidiary of the AAI, that is the AAI CLS, but they could not. Period of 2 years. Thereafter, we signed an MOU with the Guwahati International Airport Limited. They have instead clarified that this is not subleasing, my lord. That is at, my lord, page number 65. That is a clarification. Para number 1, this is to clarify that AIDC has not subleased the CPC facility to GIAL. AIDC has invested enormously to create the facility and handed it over to AICLAS for operating soon after the completion in the year of 2021. The facility remained unused for about 2 years, which was leading to damage several machineries installed by AIDC. This is also pertinent to the fact that AI has handed over the airport to the GIL with effect from 8 October 2021. Therefore, after completing due formalities with AICLAS, the facility has been given to GIL for operationalizing and maintaining it immediately. It has not been subleased. This is also confirmed that GIL has not subleased to any third party, but only engaged a competent service provider to run the CPC. So that has already been clarified. Now,
But that is the dispute, whether you have subleased.
yes, yes. So my
No,
lord,
when the interim order was, when the
now
notices
they
were
have
issued,
issued the notice at page
When?
number 72 on 18/7/2024.
18/7,
Yes,
what was the next date?
they said that we are to vacate the lease land
No,
as
no.
is
Before the trial court.
trial court, my lord, impugn order was passed on 1st of August.
1st August.
1st of
When-
August
when is the next
2024.
date?
Next date is fixed on 30th September. Without even considering, without even writing a line as to why the interim injunction was not granted, notice was issued. If your lordship will kindly see the order, actually, my lord, we had also filed a petition for exemption of the 80 CPC notice. That should have been registered as a separate miscase, but the learned court below passed the entire order in the same case where this injunction petition was pending. Your lordship will kindly see the order starts with the instant miscase arises out of the petition number filed by the
At
petition
which page you are reading?
at page number 74. The order, impugn order. Though it starts with the miscase,
Who is the opposite party here?
opposite party primarily is the Airport Authority of India. If your lordship will kindly see the,
It is represented by standing council here in the
No.
central government standing
no,
council.
no,
Who represent? There is no standing council.
perhaps there may be.
Then we are issuing notice, let them appear. We are fixing a short date.
But my lord, the thing is that, my lord, we have, my lord, sought protection.
Now,
Under-
what
it's-
what
we-
notice has been issued to you?
My lord, lordship will kindly see the last lines.
Which para?
Page
which-
number 75. The plaintiff is supported by affidavit, duplicate copy has been
No,
filed.
okay, okay,
Issue notice to the OP, nothing is mentioned.
okay. That
Nothing-
is 30 September, next day.
Yes. And the
And what is your urgency?
and most important thing is that, my lord, we are a state-run corporation. The money which we have invested is public money. And my lord, there is already a union cabinet decision for setting up of this cargo center. And my lord, I have instruction, my lord, this matter will be taken up at the highest level and these differences will be sorted out. But since, my lord, there is a notice for vacation, my lord.
Which notice?
Notice, my lord, is at page number 72. The second line from the bottom, it says that we are to vacate the lease land as is where is basis by 1st of August 2024. That has already expired.
Date has lapsed.
Yes, yes. And nothing has been discussed by the learned court below and straight away notice has been passed to the opposite party. So, my lord, some protection, my lord.
Now, if you don't vacate,
Yes. My lord, we have primarily filed this suit
no,
under
let
section
me
5.
understand. If you don't vacate in pursuant to that notice
Yes.
issued to you by airport authority,
Yes.
what options are available to them?
They may vacate, they may dispose us from the land.
Then they have to come to the court.
Yes, but they have not done so. Instead, actually, my lord, under section 5 of the Assam Urban Area Non-Agricultural Urban Area Tenancy Act, they must
obtain due procedure of law and which is described under section 5 of the act, they will have to file a suit
Suit.
for eviction. That they have
Then
not
you
done.
will get sufficient time. Then where is the urgency? There is
But they
a,
have not done so. That is,
They-
well,
they-
their intention is clear
No.
in this notice.
they have only issued notice.
Yes,
If you don't comply with the notice,
yes.
they have to take recourse to the law.
But if they do not,
Then you come. There is,
no.
how you will you presume, how are you presuming that they will not comply with
Since
the?
why not instead of issuing the notice, they should.
Why
have
I
come
am
straight to
putting
the
these questions? Because whether to give you relief without hearing the other side.
Because my
Airport
lord,
Authority of India may be likelihood that they will be represented by Central Government
yes, my
Council.
lord, we can issue notice, my lord.
You-
We have no difficulty. But the thing is that, my lord, we have come under section 5 of the act, where specific protection is given to a tenant who has raised permanent structure within 5 years from the date of the lease, and we have done so. We have raised permanent structures amounting to around 15 to
No,
20 crores.
they have
So
not
we
yet.
need some protection, my lord. So their intention is clear from the notice.
Protection would be necessary if there is something imminent.
That is clear from the notice itself.
But
Before that, my lord, we have also responded to their legal notice.
no,
we have
you
responded.
have to satisfy me
Yes,
that by mayor giving you this notice, you can be evicted without taking recourse to law.
that we understand. That is why since they have not done so, they have not come to the court.
They will come, they have to come to the court
Yes,
for
they have
evicting.
to. But
Then you will have sufficient time.
if they do not, that is our apprehension. Because
No,
my
why,
lord, we
why are
have
you saying that they will
no,
not?
we have already responded to the legal notice. The response is at my lord, page number 70, where we have clearly said that we are a tenant.
Mhm. No,
And
Mr. Das.
thereafter also they have issued this notice.
You
making their
have to,
intention very
you have
clear.
to satisfy that apart from issuing this notice,
Yes,
they have done anything which, due to which you apprehend that they may not take recourse to law and they may evict you.
because my lord, because the they,
Then there may be an urgency for issuing an ad interim ex parte protection. Otherwise, notices have to go in this case. We may fix a short date. You have made Union of India as
yes,
party. Give notice to the standing council of this union government.
but
We-
my lord, if your lordship will kindly see the notice. They have made their intention very clear that also third line, also reference may please be made to your letter number ECF so and so regarding execution of a phase lease agreement for land allotted to establish a CPC. The matter was taken up with the competent authority at
No,
AICFT.
I have understood.
Yes, so they have, my lord, by issuing this
But
notice.
this notice has threatened you,
Yes,
but you know they cannot evict you without taking legal
But
recourse.
if they evict us, my lord, we are, my lord.
There is nothing,
Loss, my lord, irreparable loss, my lord,
There
we
is-
are going to
there
face.
is nothing on record to show that they will evict you without taking due course of law. It only alerts you, notices to alert you that they are taking recourse to evict you.
But if your lordship will see the three golden principles of injunction, my lord, everything is our
No,
favor.
no, we are not on that. We are now on the question whether you should be given relief
At least till the
without,
return.
no,
we
without
notice.
hearing the other side. Is the urgency such that without hearing other side,
Because my lord,
relief?
the period has already expired. The date of, my lord, the date.
Period
they
of
have
notice
fixed is
has
1st of
expired.
August. Today is 16. So, my lord, at any
They
time,
cannot forcefully evict you.
but that we cannot apprehend, that we cannot know. What action they contempt are
No, you have
contemplating.
not alleged that there is an attempt of forceful eviction. So that this court may come to an finding that they may.
If your lordship will kindly see the injunction petition,
No, Mr. Das, we are issuing notice, we are fixing a short date.
my lord.
You take steps for issuance of notice. On respondent number 1 by serving notice
Yes,
to
one is-
standing council,
We have already served notice upon the respondent number 1.
but their names have not been shown.
In the cause list, my lord, their names appear.
Okay. to inform COM. We'll take up it again. Let somebody from their panel come. We'll take it up at 2 again. DY is Deputy Solicitor General of Qatar scrolling video. We'll take it up. Otherwise, I'm intending to issue notice with a short date.
Madam.
If you are insisting on ad interim relief, then we have to,
We are here, ma'am.
then
Since
we are,
did not get the relief in the.
then we will have to hear the other side.
Highly obliged,
At 2, we will take it up.
my lord. May I please your lordship?
My lord, bail application is placed before your lordship because, my lord, there is a bail application pending in respect of co-accused, my lord. Where your lordship has passed at order, my lord, granting some protection, my lord. I have the orders, my lord. So this is the reason, my lord, why, my lord, this bail application is placed before your lordship. I am on parity, my lord. Because he was the, my lord, president of this committee, my lord, and petitioner before your lordship is the secretary of the same committee, my lord. Allegation is, my lord, against both of them, my lord.
No, this should not have been,
Yes, my lord.
because I have not disposed of the matter. This bail application could have been taken by anybody, any
Yes,
bench.
yes, ma'am.
The notification says that if I have disposed of if court has disposed, then it should come.
Yes, my lord.
But merely by passing an order,
Yes,
it should not have come to this court.
yes, my lord.
Oh, but there is an. Okay, what is your submission?
Yes, my lord, in fact,
What
my lord,
happened on 30?
my lord, on last date, my lord, CD did not receive, my lord. And one person, my lord, he claims to be the victim of this, my lord, activities of this committee, my lord. And he has,
Who are you?
I am the secretary, my lord. Secretary of this committee, my lord. Here allegation is that, my lord, on the basis of complaint of, my lord, the fair price holders, my lord, that they are receiving, my lord, short delivery of rice, my lord. So that is the basic, my lord, allegation, my lord. And on the basis of that, my lord, there was an inquiry by the authority. And my lord found that, my lord, there is some excess, that is 41 point something quintals rice were found in my godown, my lord. In fact, that was to be supplied to some schools, my lord. 5 numbers of schools, my lord, that was stored in my godown, my lord. In fact, this, my lord, authority, he, my lord, anticipated that it's going to be, my lord, diverted to, my lord, for open market. So that is his own assumption, my lord. Accordingly, FI is lost, my lord. In fact, I have, my lord, annexed, my lord, my lord, my lord, applications of the 5 schools, whereby it is, my lord, they have requested that whatever is remaining, my lord, they are to receive from me, my lord. They are coming and, my lord, they will be receiving, my lord. So your lordship will kindly come to, my lord, page 15 onwards. I have annexed these all, my lord, applications of these 5 schools, my lord. So this is in my SOCO's reply also, whereby, my lord, my license has been sought to be cancelled, my lord. Page 15, my lord. Page, therefore, my lord, last, my lord, 6, therefore, I
What
have.
is page 16, 15?
15 is, my lord, the applications by the, my lord, school headmasters saying that they are to receive the remaining rice. In fact, case memo is already received, my lord, issued to them, my lord, saying that, my lord, the remaining which rice is receivable by them, my lord, that will be delivered shortly, my lord.
Yes, Mr. Busher.
My lord, here the allegation is about the misappropriation of the PMJKY rice, my lord.
And from the custody of the secretary, it is stated in the FIR that 395.63 quintals of that PMG KOY rice and MDME rice from the possession of Gyasuddin Ahmed. Gyasuddin Ahmed is the present accused petitioner.
You don't stand on the same footing as
Now, in
My
fact,
president.
my lord, we are on the same footing because if you lordship kindly come to the my lord FIR, my lord, this is against the my lord president as well as the my lord secretary, my lord. At page 35, my lord, this is the FIR, my lord. If you lordship, my lord, last paragraph, my lord, I read, my lord. But I found a physical stock of so-and-so quintals of so-and-so rice in the godown. And so an excess stock of so-and-so rice was found in the godown. The excess stock of so-and-so quintals of so-and-so rice illegally accumulated by the secretary and president of MS Nagapanta GPSS for illegal diversion to the open market for illegal monetary gain by making short delivery of so-and-so rice to the FPs of dealers. So this is, my lord, again, my lord, at page 36, my lord, same allegation against this both the persons, my lord. Then next page 36, my lord, third paragraph. If you
No, in the order which you are referring, 9/8/2024 order,
Yes,
nothing is mentioned.
yes,
Only that no coercive action
yes, ma'am.
that has no binding effect on any court. If there is no reasoning given why that order, there is no reasoning in that earlier order.
In fact, that is, my lord, if that order is also passed by,
No, this order was given in an anticipation that case diary would arrive on 13/8.
yes. And that day, my lord, case
That-
diary did not receive. my lord.
Yes.
So
Such
if-
order does not give protection to co-accused.
That is not an interim protection, madam.
Then your lordship may, my lord, give some protection, my lord, because apparently, my lord, there is no case, my lord.
No, we will call for case diary,
Short date.
short date,
No, that is
Today
there, my lord.
motions
because
is
it is
lordship.
found in your
No,
possession.
that is there, my lord, because it's not that it's, my lord, found from some other go down, my lord. It is, had there been any intention to, my lord, place it before some other place, my lord, for black marketing.
When can you bring?
My lord, my lord, 22nd. More
My lord,
22nd.
other case, my lord, that is fixed on probably, my lord, 27.
22nd.
That's why, my lord, I am seeking some protection, my lord, because, my lord, if your lordship kindly come to my lord, let me, my lord, here, my lord, on merit, if otherwise, my lord, if kindly lordship come to page 28, my lord. This is, in fact, my lord, the declaration of these fair price of that, they are not getting any short delivery. Page 28, my lord. This is the type copy and 29 is the vernacular, my lord. This is declared by them, my lord, that they are not getting, my lord, any short delivery.
Then from where this excess rice was found?
My lord,
If they are not getting any short delivery,
yes, yes.
then from where that excess?
That is, my lord, yes, my lord. That is, I have, my lord, annexed these applications of these spools, my lord. 5 spools, they are to receive the remaining rice. Already they have got the, my lord, main, my lord, portion of their quantity, my lord. Your lordship will kindly come to for a moment, my lord. I have annexed this, my lord, their
Where is the FIR?
FIR is at, my lord, page 35. Page 35. This is the main allegation, man. That they are getting short delivery, man. And they have themselves declared that they are not getting, my lord, short delivery. 29 fair price of dealers, they have, my lord, put their signature. In fact, it is the case, my lord, the vice chairman, my lord, who has the intention to remove the chairman from the, my lord, committee, my lord. So this conspiracy is hatched up, my lord. Page 35 is the FIR.
Heard Mr. J.C. Bora, learned counsel for the petitioner. Also heard Mr. K. Bushra, learned additional public prosecutor. this application under section 482 of BNSS 2023 has been filed by the petitioner Gyasuddin Ilyas Gyasuddin Ahmed, who is apprehending his arrest in connection with Lahori Ghat PS case number 142/2024 under section 315/316 within bracket 4, 3/318 within bracket 4/320 of BNS. The gist of accusation in this case is that on nine seven 2024, who lost the affair?
That is my lord,
The assistant
yes, my
director
lord, assistant director.
who Public Distribution and Consumer Affairs from Morigaon lodged an FIR before the officer in charge of Lahori Ghat Police Station, inter alia, alleging that Messrs. Nagabandha GPSS has been involved in the malpractices of PMGKY Rice. Stop. The present petitioner is the secretary of the Messrs. Nagabandha GPSS. Stop. It is alleged that the rice PMGKYK rice, which was meant for distribution to schools,
In fact, my lord, to the fair price shop, my lord.
to the
Allegation is that.
fair price shops, was not distributed properly, and during inquiry, 88.87 quintals of PMG rice and 395.63 quintals of MDM rice was found. From where it was found?
That is in my godown, my lord.
In the godown of Messrs. Nagabandha GPSS. What is your submission regarding this?
My lord, this what excess is found, my lord, that is meant for supplying to the schools, my lord, remaining rice, my lord.
Stop. Learned counsel for the petitioner has submitted that the Nagabandha GPSS have been supplying the PMG KYK rice to the fair price shop without fair price shops regularly, and to that effect, the declarations have been given by 29 owners of fair price shops under Nagabandha SS limit. Nagabandha GPSS. Wherein they have declared that there has been no short delivery of the rice. Stop. Learned counsel for the petitioner has submitted that the rice which is found in the godown of GPSS was meant for supplying to the school
Yes.
And this rice is the excess rice which remained after supplying to fair price shops.
Yes.
Learned counsel for the petitioner has also submitted that the police is searching for the petitioner and he apprehends that he may be arrested in this case. He also submits that one of the co-accused, namely Abdul Mateen, who is the chairman of the Messrs Nagabandha GPSS, has been given interim protection by this court by its order dated 9/8/2024, passed in AB case number 2060/2024. And the next date is fixed on 22nd August 2024 for case diary. He submits that he is learned counsel for the petitioner submits that the petitioner is ready to cooperate in the investigation. Stop. On the other hand, learned additional public prosecutor submits that the main allegations made in the FIR is against the present petitioner only, and therefore he opposes grant of bail without perusing the case diary. Stop. However, let the case diary be called for and let this call for fixing 22/8/2024 for case diary. Let this case be listed along with AB case number 2060/2024 on this said date. However, considering the fact that the co-accused has been granted interim protection during the period before arrival of the case diary, the present petitioner is directed to appear before the investigating officer of
Lahorigarh Police Station.
Lahorigarh PS case number 142/2024 within a period of 5 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with Lahorigarh PS case number 142/2024, the above named petitioner shall be allowed to go on interim bail of ₹30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Let this case be listed again on 22nd.
Diplomat.
May I please? Well, this is the revision petition, 227. Grievance is that the suit which has been filed in the trial court against the petition,
Against the petitioner,
present petition, is apparently a facetious suit. It does not disclose the cause of action and barred by time. The plaintiff is prepared in such a manner that They are trying to conceal the exact date of their knowledge for filing the suit and coming at a very, very belated stage.
No, whether notices are served on.
Notice was served, but nobody has turned up. And on the last two occasions also, despite the notices having been served, court gave some chances that let us for the answer of justice. Lordship may kindly see the order, first order of Justice Medhi, dated 26th of February 24. I don't know any. Oh. You took quoted time because the last sunset of this week. Justice Medhi. Order to court. Well, the last but one order. Last order was passed by Justice Parthiv Saikia. Also granting some more time if they make their appearance before the Honorable Court. Earlier, when the matter was heard, it was heard at length. After the court came to the conclusion that if it is allowed,
No, where is the order dated? 13/2/2024.
13
13/2/2024.
13/2/2023. That was probably the order by which satisfaction was recorded. July 13.
This is office note dated.
Office note which says office note dated 13/2/2024. That has been referred to on dated order dated 19/7/2024. That was earlier also referred to in order dated 26/2/2024. Then again on 19/7/2024. That already been served, but still none appears for them. This court on the last occasion gave one last opportunity to the respondents to appear, but today I had decided that the respondents should be given one last opportunity to appear and contest the petition. Despite all that, nobody is turning up. So they are not interested as it appears, having realized probably the fate. Otherwise, there is no reason why not. They should come and contest this petition.
Just a minute, let us go through office note.
Yes.
Dated 13/9. 13/2.
13P. Probably notice was accepted by one of them on behalf of all. They all are the mother and sons. Resident of residing together.
File part to file. Report of the processor. But the respondent number 1, while receiving the notice, has mentioned that she is receiving for serial number 2, serial number 9. So not in between. She has- She has received only for serial number 2 and serial number 9. Though the report of the process server mentions that it is from 2 to 9.
Yes. But Lordship finds it
It is,
report,
yes, it is 2, 9.
Right.
To dekha hoga.
not 2 to 9.
You please go through. It is not 2 to 9. So that is not proper service.
That is that case. So whole matter will again go to that stage.
Yes,
For the issue
because
of-
otherwise they will raise a plea later on that we have not. You may look at the,
That is. 2 to 9 has written a 2 and 9. Like the report I am reading, man.
no. I'm not saying about the report of the process server.
Yes,
The addressee, the respondent herself has written that respondent number 2,
serial number 9.
serial number 9.
That above this.
So the report of the process server does not tally with the what has been stated by the respondent number 1 in
Receive for serial number 2, serial number 9.
9, which means she is receiving for
2 and 9.
2 and 9 only,
Not-
not 2 to 9. But process
Not 2
server
to
has mentioned 2 to 9.
But the report, no, the process server has mentioned this. Lordship is right, the report doesn't tell you the exact, which is what
Just to be
the
done.
petition is. So, in that view of the matter, then the notice should go on. that.
Notice, because you have interim protection.
Yeah, the suit is not state. State, yes. Suit is state that, আমি কিভাবে petition file করেছেন? Petition file করেছেন? They are now trying to dispossess me in the meanwhile. This is the difficulty. Creating problems.
But
Yeah. Yes. What you may say that press notice should go to the other respondents. Meanwhile,
Yes.
the record will go.
okay,
Record will go. LCR.
heard Mr.
Yeah.
A.K. Mohanto, Learned Senior Counsel, assisted by Mr.
Yes, Gautam.
S. Gautam, Learned Counsel for the petitioner. On perusal of the order dated 19/7/2024, it appears that it has been observed by this court that office note dated 13/2/2024 shows that notice upon respondent number 1, 2 to 9 have already been served and none has appeared for their behalf. However, on perusal of the copy of the notice wherein the report of the process server has been given, it appears that on the back side of the notice, the respondent number 1 has put her signature, mentioning therein that she is receiving the notice for respondent number serial number 2, serial number 9. Stop, which means that she has received notice only for herself, serial number 2 and serial number 9, and not with regard to other respondents. And therefore, the report of the process server does not tally with the endorsement given by respondent number 1 on the notice, on the backside of the notice. In view,
That who has received it, he is number 1. So 1, 2 and 9.
1, 2 and 9.
Yes, one is Maduranjan Soikia, He has received it. On behalf of two
Yes,
and nine.
yes, one is served,
One is served, two is served, nine is served.
9 is served. In
No,
view of above, notices issued to respondent number 1, 2, and 9 are held to be duly served. As regards other respondents, the petitioner is directed to take fresh steps by registered post with AD as well as by usual mode. Usual mode within 7 days from the date of this order, returnable after
Month.
4 weeks.
File lodge for 40.
Records will be necessary.
Necessary.
It appears that by order dated 16/11/2023, this court had stayed the further proceeding of title suit number 423/2023 pending in the court of Civil Judge number 2, Kamrup Metro. Stop. On perusal of the revision petition filed by the petitioner, it appears that the perusal of the case record of title suit number 432/2023 would be necessary for consideration of the instant revision petition. Hence, call for the same registry to take step for requisitioning the aforesaid records. Release this matter accordingly after 4 weeks. After 4 weeks.
Yep.
Could list listening.
May I please your option, my lord? My lord, it is a revision petition, my lord. My lord, basically, we have challenged the interim order dated 26/6/2023 at page 12. The question involved in this case is, my lord,
Page.
page 12. The only very, my lord, tricky question is involved. Whether in view of the provision of, my lord, order 7 rule 9, the plaintiff is required to take steps within the time prescribed under that particular provision. If not, what could be the consequence? Then answer is absolutely clear in terms of order 7 rule 11. Because the court doesn't have any power to extend the period. And despite that legal position, the trial court says, while, my lord, rejecting the application of the defendant, saying that since court does not fix any period, therefore, my lord, the steps taken within the next date fixed by the court is, my lord, absolutely justified. Therefore, there is no any question to apply order 7 rule 11 and to reject the plate. This is the, my lord, short question involved. So it requires some adjudication on this in the sense that, my lord, there is no decision on this point in our High Court. Therefore, whether it is a mandatory or not mandatory, there are some decisions from other High Court and saying that, my lord, it is a mandatory requirement.
Which
Court-
is mandatory?
My lord, order 7 rule 9.
Order 7 rule 9.
I'm sorry, my lord, the book is not with me, my lord, I'm sorry. Order 7 rule 9. Well, may I just reading, my lord?
Yes.
Where the court orders that the summons is served on the defendants in the manner prescribed in Rule 9, Order 5, it will direct the plaintiff to present as many as copies of the claim on plain paper as there are defendants within 7 days on the date of such order, along with requisite fee for service of summons on the defendants. Therefore, my lord, there is a clear time prescribed that within 7 days, plaintiff is to take steps in the manner prescribed.
No,
Now,
no,
Lord, kindly-
it does not say plaintiff. It says court should direct,
Court should direct.
court should direct.
Court should direct, my lord.
This is a direction for the
No.
court.
Uh,
Or Order 7, Rule 9,
Yes. No,
where the
the court should order that the summons be served on the defendants in the manner provided in rule. Therefore, my lord, question of issuing summons does not arise unless that they take steps. Therefore, the question is, my lord, whether it is a mandatory requirement on the part of the plaintiff to take steps within the time prescribed. And what would be the consequence in case of any non-compliance? Then Lord should kindly may come to,
No, just a minute, let me
Yes.
go. Where the court orders. It will direct, that means what court has to do,
court is to,
that has been prescribed in
Madam.
Order
Madam.
7, Rule 9.
Madam.
Okay,
so my lord, unless,
now, is it mandatory?
is it massive? This is the question in for my lord. I am really sorry, my lord. My lord, I have gone through some decision, but I am, my lord, unfortunately, my lord, I could not read the decision properly. So, my lord, may I just make a prayer? I'm just giving an idea, my lord, for consideration. May I pray that, my lord, Lordship may take up the matter on Monday. I'll cite some decision. At least Calcutta High Court, Odisha High Court, there are some decision. Question does not arise to extend the period. Lordship may not agree.
Decision regarding what?
Regarding, my lord, whether that part of the provision is mandatory.
That court has to direct within 7 days.
Unless, yes, unless and until, my lord, steps taken, question of issuing direction does not arise. Therefore, indirectly, they are supposed to take
No, no.
steps,
What I understand
My lord.
from your submission
my lord.
is that in this case, plaintiff, after filing the plaint
My lord.
and court directed issuance of note
My lord.
summons to the
My
defendants.
lord.
But it did not mention that you take steps within 7 days.
Exactly. Therefore, my lord,
Therefore, the plaintiff did not took step within 7 days.
my lord,
Now you are before this court that even if court does not direct within
Exactly.
7 days,
My
he
lord.
has to take steps.
my
within
lord,
seven.
my lord.
What is the basis? I don't find any basis. for-
Otherwise, my lord, the first part of the provision of, my lord, 9, Rule 9, that would be redundant. That doesn't have any meaning.
Rule 9 of
Of, my lord, Order 7.
Order 5, not Order 9.
No, Order 7, Rule 9, I'm referring. My lord, my lord, I'm reading one thing for your consideration by this court, my lord. Where the court orders that the summons be served on the defendant in Rule 9 of Chapter
No, I
5.
don't see much difficulty in this case.
Lordship is absolutely clear, my lord. I am not clear. That's why, my lord, I need at least 2 days time so to prepare the case in a more effective manner.
Yes, Mr. Alam.
I'm sorry, my lord, for the inconvenience.
Call a state and
Prayer for adjournment.
Well, already adjournments have been taken, my lord. Your lordship cannot.
Any-
Any,
any
Oh,
stage
you
there-
have taken a-
no.
Matter is not,
Earlier,
not
my
a-
lord.
matter
Earlier,
is a small matter in this.
my lord, very small matter. Matter becomes transparent and clear enough. For a presumption of, my lord, this improved order itself, my lord.
Because here it appears that plaintiff was not at fault.
My lord,
He was not directed to take steps
within
within
7
7
days.
days.
By the trial court.
Had there been such a direction,
Then
then there is a question of rejection
fault
of.
attributable upon the plaintiff.
Plaintiff.
There is a my lord, submission they have made even in the court below.
But Mr.
My
Purkasta says that
see-
there are judgments of,
Yes, yes.
But
I have
what-
gone through, my
whatever-
lord.
let
what-
him bring the judgments.
Yes, yes.
But whatever, with all established, whatever.
Well, my submission is that, my lord, there is no any question for the court to issue any direction to take steps within the certain period. Because time is already prescribed in this section itself.
No, no, no.
That is the manner of view taken by other High Court. If I'm not wrong, my lord.
Okay, let us see.
That's right.
Lordship, what, let it be adjourned, my lord, but only I am drawing the attention of this one. Your lordship cannot see.
It gives a clear direction to the court,
Court, my
what court should do.
What should do?
If
my lord,
court
if-
fails to do that,
Then
plaintiff cannot be
They ought to
penalized.
have challenged that particular order, my lord.
That you give a time.
That particular order. This is illegal. That has not been
But
challenged. my
let
lord.
us see the judgment.
Yes, yes.
Heard,
But
Mr.
those are persuasive, my lord.
No, still, if something reasonable is there. Heard Mr. A.K. Purkayastha, the learned counsel for the petitioner, also heard Mr. N. Alam, learned counsel for the respondent. Learned counsel for the petitioner submits that before he makes submission in this case, he has certain authorities to cite which he could not bring today, and therefore prays for listing this matter on another day. The prayer is allowed. Let this matter be listed again on, when do you want?
Monday, my lord.
As well,
If possible, my lord.
subject to convenience, Monday, Tuesday.
Let it be on Tuesday,
Well, Tuesday.
on Tuesdays, 20th of August.
No, no,
Thank you.
my lord, this is Tuesday.
My lord.
My lord,
Now,
so I am having difficulties. Tuesday morning, my lord, I am leaving Guwahati, my lord. For admission of
according to
my-
your, to me, want it.
Monday, my lord, I shall be able.
On Monday,
Monday, my lord.
Monday, that is 19th of August.
My lord.
Much.
Portion is small, but effect is for reaching money.
Okay, let us see.
Well, there is an interim, my lord, order that may.
No, no, my lord, that
Yes,
also
yes.
has, on last occasion, my lord, honorable court has refused to extend the same, my lord. There is no extension. On last order, your lordship, I can see.
No, that's
There was
okay.
no extension.
Now, what is this? No, it is not a case of stay.
My lord.
My lord. As a lordship. to you.
In spite of that, my lord, since the date of service of someone, my lord, 4 years have been passed, my lord. 4 years.
It is because of you. I have to show on record. There was a
On-
continuous lapse on your part.
On what day? Much.
My lord, this item, if it can be taken up on some other day.
Why?
Maybe admission.
Because, no, it is at the admission stage, because there are certain things supported by some authorities. And
You are not ready.
I could not be ready for this item today.
Maybe it is small matter, my lord. Section 6, my lord, specific relief, my lord. Learned trial court has to decide the, my lord, disposition, my lord. The learned trial court cross beyond the jurisdiction, my lord, deciding the merit of the case, my lord, which is not permitted under the law, my lord. It's a simple question, my lord.
We can admit it,
My lord,
Yes, my lord.
there is no point for admission.
admission.
Yes,
Okay,
this very item is not
okay, okay.
liable to be
Then,
dismissed at
then
the
let us
threshold.
My lord.
heard Mr. S. Soikia, learned counsel for the petitioner. Also heard Mr. D. Nandi, learned counsel for the respondent, who prays for an adjournment on the ground that he has to refer to certain authorities in support of his case, and he could not collect the same today, for which he needs some time. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed again on after a week.
After a week, my lord.
No fixed date.
No, if date can be fixed.
No, no, no. After a week on a date to be fixed by registry.
Interim order may continue.
The interim order shall continue.
Let it.
Yes.
Yeah. The petitioner is absent.
Oh.
And the respondent. not absent.
What is to be done?
The petitioner came against an
No, now you have to submit that as petitioner is not there, should we dismiss it or should we,
Yes, my lord. Let it be dismissed.
what is the matter?
The petitioner came against an interest, solitium interest on solitium ground, which was passed by the Honorable Learned Civil Judge Senior Division Karbi Anglong, D4. In a money suit.
Okay, let
Number-
us not dismiss it today. We fix another,
Last time also, day before, last time they was also absent.
but last
Mr.
time, on
Yes, my
last
lord.
occasion they appeared.
Yes, the last time they had appeared.
Who is appearing?
ACB, I think.
Heard, Miss
MD Medhi.
MD Medhi, learned counsel for the sole respondent. None appears for the petitioner on call. Let this matter be listed again after a week on a
A
date.
date may fix, my lord.
Let this matter be listed again on 27th of August.
Yes, my lord.
2020.
Oh, yes.
Please, Lordship.
Yes. What
In
is
this
it?
case, a suit was filed by the sole respondent, Lordship, showing as a tenant of a house. The suit was under the Rent Control Act. Suit was dismissed. Thereafter, appeal filed, appeal decreed,
Repeat,
decreed.
decreed.
Yeah, appeal was allowed.
Reverse.
Yes.
The order was reversed. Judgment
Oh.
was reversed.
Yeah, judgment was reversed.
And
Then-
your eviction was ordered.
Yes, eviction order. Then they filed execution case. We filed a petition under section 47 of CPC. That has been rejected. That is repeat.
Records would be necessary.
My lord, it's a very simple case, my lord, your lordship will find. My lord, it's a suit under Rent Control Act, my lord. Landlord tenant dispute, my lord. Court has earlier, my lord, prior to filing our suit, my lord, as a plaintiff landlord, my lord.
No, but this is a case of reversal, not
my lord.
concurrent finding.
My lord, lordship kindly consider, my lord. My lord, that was, the appeal was allowed. Then it was decreed that the defendant is liable to be evicted from the suit premises.
Just a minute,
Now,
just a minute.
my
Mr.
lord.
Lee. What is your ground for?
Lordship, my ground is earlier they have mentioned.
Absolutely no ground, my lord.
Yes.
My lord,
Earlier-
they filed an,
Let me
I'll come
submit.
to you. I'll
Yes.
come to you.
my lord.
Earlier, Lordship, in the 1960, they filed a suit showing my predecessor as a trespasser. In that suit, it was dismissed, landlord-tenant relationship in respect of land. And it is specifically stated that I am a tenant as a land. Now in their plaint also, they have, in the schedule, they have given land. But filed the suit under Rent Control Act. So this is a nullity.
Okay.
This is a nullity.
It should have been,
I am protected under 1955 Act. And San has this sole respondent's plaintiff's predecessor earlier filed as a trespasser suit, and the whole landlord-tenant relationship was held in respect of land.
no, whether you took this plea before the first appellate court.
Actual first appellate court, yes, this was taken in the form of res judicata. It was taken, and this is a question of law, Lordship. This is a question of law. Before any court, it can be taken up. Even the plaint itself shows is a land. It's land. Landed house.
Okay. So
It does not come under the definition of
So-
house.
they filed a suit, they filed the suit under wrong law.
Yes, yes.
That is your main contention.
Main, we are protected under 1955 Act.
Okay.
1955
sir.
Act cannot be evicted.
We are not hearing
My
it
lord,
today. Only question whether to admit it or not.
My lord, it's not a case of admission even, my lord. Because, my lord, in a case under what they have, my lord, pointed out. My lord, suit under Assam Urban Areas Non-Agricultural Tenancy Act. They say they are protected under section 5 of that particular act, Assam Non-Agricultural Urban Areas Tenancy Act. For that, my lord, there has to be a lease deed in between the lessee and the lessor. Where is that? My lord, in the earlier suit, the court said, my lord, that they are tenant and we are landlord. It has been established by their suit. Prior to filing my suit, my lord, they have filed a suit for tenancy right under Rent Control Act. And in that suit, my lord, the learned, their suit has been dismissed, and in that court, my lord, it has been held that there is a relationship established by the landlord and tenant, and they are defaulter in payment of monthly rent. But based on that, we have filed this suit, my lord. Now, rent suit can be filed, my lord, time and again, your lordship knows, my lord, recurring cause of action, my lord. Because if there is a cause of action, my lord, rent suit can be filed time and again. Not necessary that once we have filed, my lord, it cannot be filed later on, because it's a recurring, my lord.
In respect of
Every
land-
month, let me complete. I did not disturb you. I did not disturb you.
Yes.
My lord, in view of the Supreme Court judgment, my lord, and as well as our High Court judgment, my lord, the rent suit can be filed. There is no question of res judicata. If there is new cause of action, rent suit can be filed under bona fide requirement, under, my lord, defaulter, under nuisance. These three grounds, my lord, it can be filed at
Where
any
is the
point.
copy of plain?
My lord, plain, my lord, they have filed, my lord, I have
Page
annexed.
number?
Yes.
Copy of the plain lordship, page 18, starts from page 18.
Where is the schedule?
Schedule page 23. District Kasar, Pargana, Barakpur, Mauja, Tilchat Town, Gopalganj, second as pattern number 449, Dag number 3796, land measuring 2 cut of 4 chataks with Assam type structure.
Assam time house.
They are trying evicting from land.
No, my lord, this house as well as land, my lord, house will stand where? Over the land, of course. My lord, this house was given on
Right.
monthly rent to the, my lord, predecessor of the present, my lord, the petitioner.
Lordship may also kindly come to page 132, Lordship.
Then, my lord, kindly see, my lord, the judgment of the appellate court, my lord. At page, my lord, 65. Lordship may kindly come to the page 65, everything will be clear, my lord. Then, my lord, they filed, my lord, absolutely for stalling the execution proceeding,
No.
my lord.
Let me
My lord.
put a query. On what ground the trial court dismissed the suit?
Trial court says, my lord, this is in judgment
Failed
says
to prove defaulter.
defaulter. That is
No other ground.
that is the, my lord, error on the part of the learned trial judge, my lord, who it has been interfered with by the appellate court, my lord. Your lordship kindly see page 65, paragraph 13 of the appellate court judgment. Issue number 5. Whether he is a defaulter, and, my lord, whether there is a landlord-tenant relationship. That has been dealt with, my lord, by the learned appellate court. And
Question is-
against that, your lordship
No,
kindly
no,
consider, my lord,
question is
against
whether
that,
this rent control act attracts here or not.
my lord, against
main
that,
question.
my lord, for a case under Assam Non-Agricultural Urban Areas Tenancy Act, there has to be a lease agreement, my lord. Let us very clear on this point. That lease agreement is not there. And in that particular lease agreement has to be registered under section 108 of the Transfer of Property Act, section 17 of the Registration Act. Where is that lease deed, my lord? If he says that we have given the land on lease, my lord, where is the lease deed? My lord, they have filed a suit, in fact, my lord, in our plain we have categorically stated in the year 2004, they have filed a suit for their tenancy right, my lord, on the Rent Control Act. Now they are changing their plea, their stand, my lord, that they are protected under non-agricultural Assam Urban Tenancy Act. Two contradictory pleas. That has been, my lord, categorically, my lord, decided by the learned appellate court. Appellate court says, my lord, that is why the my lord, trial court judgment has been reversed. My lord, paragraph 65, page 13, paragraph 13 may kindly be seen, my lord. Page 65. This issue is considered as most vital issue. Issue number 5.
Okay, page
The relationship of, my lord, page 65. Page 65, paragraph 13. The relationship of landlord and tenant is denied by the defendant, but the defendant did not adduce any evidence to prove the same. Has your lordship got it, my lord?
Yes.
Paragraph number 13. Issue number 5. This issue is considered as most vital issue. The relationship of landlord and tenant is denied by the defendant, but the defendant did not adduce any evidence to prove the same. Moreover, on perusal of the Exhibit 1 and Exhibit 1.1, it is clear that the plaintiff is the landlord of the defendant, as the defendant himself in title suit number 112 of 2004 addressed the plaintiff as his landlord. And the relationship is further affirmed in the title suit number 114 of 2014. They filed this suit prior to this suit, my lord, filed by us. Hence, giving a
Yeah,
false.
What is this? 112?
Yes, 112 is filed by them,
Why?
tenant, for their protection of tenancy right.
Over?
They say that they have a apprehension that we forcibly
No,
evict
no,
them.
over a plot of land or?
Over the suit house, my lord.
Where is that?
That is there, my lord, in the suit they have said, my lord.
Where is the? What is exhibit 1?
Exhibit 1, my lord, is the summon, my lord, that has been, my lord, I have in the trial court judgment, your lordship will get. Now, my lord, lordship kindly come, my lord, page 30. My lord, page 32 is the relevant part, my lord. Decisions, discussions, reasons thereof. My lord, trial court judgment. Has your lordship got it, my lord? Second para, my lord, plaintiff of this suit examined himself as PW1. His evidence in chief remained unrebutted, as he was not crossed, nor any contrary evidence was given by the other side. PW1 in his evidence in chief supported facts, in chief supported fact in plaint. PW1 exhibited 2 evidence, 3 documents. Exhibit 1 is the summon issued in title suit number 112 of 2004 by Court of Learned Sodor Munsif 1, Silchar, addressed to the plaintiff as of this suit. Exhibit 1.1 is the copy of the plaint. Why not plaint in the suit of title suit number
No.
112 of 2004?
It shows that he prayed for declaration of his tenancy right over suit land.
No, my lord.
That is the observation.
No, my lord. Copy of the
Now-
title suit number which shows
Now,
defendant
Mr.
number.
Sen,
My lord.
in this case, they have taken plea that whether the Assam Urban Areas Rent Control Act 1972 would be applicable or 1955 Act would be applicable.
My lord. That is clear by the judgment, my
No,
lord, of
the
the
judge-
appellate court as well
the-
as the.
The
my lord,
trial court says that they filed the previous suit claiming tenancy right over land So this question has to be looked into after perusing the records.
My lord, tenancy right,
Without records, it may be difficult.
my lord, your lordship,
We are admitting it.
my lord, lordship kindly see the impugn order. For a moment, my lord. Impugn order. My lord,
No.
impugn order is, they are taking, my lord, contradictory plea, my lord. That is why, my lord,
No,
I am, my lord, opposing, my lord, like this. Your lordship kindly see, my lord, the impugn judgment at page,
Yes. Which way?
my lord, page 100. Your lordship will find. Miscellaneous appeal number 9 of 2019. My lord, it starts from page 99, annexure 9. Now, my lord, your lordship kindly come to page 109, paragraph number 13 of the miscellaneous appeal, my lord. First, they have filed an application under sections 47 of CPC, my lord, in title execution case, my lord, for the purpose of delay the, my lord, execution proceeding, nothing else. That was rejected, my lord, by the executing learned executing court. Then they preferred appeal. And that was also, my lord, rejected by the learned, my lord, appellate court. Your lordship now kindly come to
No,
the
why this was miscellaneous appeal was filed?
miscellaneous appeals under section 47. They say,
filed, Lordship. So directly revision should have been filed.
my lord, your lordship
Yeah,
kindly,
that's
kindly appreciate one aspect of the matter, my lord. The appellate court judgment, my lord, and decree, which has decreed, my lord, for their eviction, that was not, my lord, assailed by them, my lord.
They are assailing it now.
They are assailing it in the execution court case, court, my lord, by filing, my lord,
That was
47
wrong.
application.
That was wrong. That was a wrong. What happened? It was dismissed.
Yes.
That was rightly dismissed. Now the question is the plea which he is taking. At least we have to go through records. Without going through records,
My lord, kindly come to page paragraph 13. Paragraph 13, 109.
no, that relates to executing court.
My lord, now can executing court, my lord, go beyond the decree, my lord?
That is not the question before this court.
They raised this plea before the executing court.
That-
Now
that is-
against that they have come, my lord.
Here,
Yes,
If decree
That-
becomes
that point, my lord,
Non-executive
they have
court.
raised before the trial court, executing court.
here you are before the, which is the order which you.
Yes,
you are-
my lord, this order,
executing court, Lordship, executing.
executing court.
Section 47.
Executing court's order rejected their, my lord, petition
Because
filed under
decree is
section
non-executable.
47.
If decree is non-executable, then executing court can decide the issue, Lordship.
And
We are saying this is nullity. Earlier suit, it's in 1960, it has been held that we are tenant. And this is the we are protected under 1955.
but nullity point has been dealt with by the trial judge as well as
You
appellate
have not
court.
challenged the appellate court's order. You are not challenging.
No, that is not, my lord.
You are not challenging the
No.
appellate court's order.
That
This
is
is
finality, my lord.
After all these years, Lordship.
My lord, my lord, that
Directly
attains,
challenge it.
that attains finality, my lord.
When the appellate court order was
Yes,
passed.
that is, my lord. That is, my lord, your lordship kindly.
Page 59.
Okay, I'm taking a short break.
My
After
lord,
that-
at page 59,
No,
annexure
Mr.
4.
Sen, wait, I'm taking a break for 2 minutes.
My
After
lord.
that, you have to make your submissions.
Lordship.
7th,
Next date, Kitya.
6th on 27th of this month. I'm just
But
waiting-
other party, what order we have passed?
Lordship, the matter is fixed on 27th, showing that none appears for the petitioner side. I'm waiting for the petitioner, Lordship.
Only the interim order may be continued, Lordship.
Okay, interim order will continue. You inform the other side.
Lordship,
That
I have
this
already,
order
already talked to them. Already talked to them.
Lordship, item number 6, you have put your upon my mistake. The notice was served by register ready to some of them. That may be seen, my lord. Because register it was sent, by process it was sent. In the register, they have received some of them. That may be kindly, file may be kindly seen. But by through process it was sent.
Then we have to again go through the record.
Register ready.
No, we will go through the record.
No, my lord, some of them have.
I have
already-
understood. That means not against what we have ordered, that 1, 2 and 9.
Yes,
1, 2 and 9 served
served by process server.
by process server.
By register ready, that was not seen, my lord. Register ready, 4 and 5, I saw 4 and 5 probably receiving. They avoided, but 4 and 5, that lordship may kindly see the file,
Okay, we'll take it up again.
my lord.
We'll take it up again. If
After?
we, after lunch,
Okay.
we'll take it up. We'll verify whether
Yes,
then we will,
fine, yes. Because my junior told me that register ready, they received.
if required, we'll correct the order.
Yes,
Yes, Mr.
Before Lordship, I take your Lordship
Mr.
to records.
What is your name?
SD Purkasta.
Mr. Purkasta. Which order you are impugning? Which order you are impugning?
It is at page Lordship 83. Page 83. If before that Lordship, may I
No,
please-
no. Let me put my queries. You have not made, you have made things clumsy. Because I was under impression that you have come against the
Appellate order.
appellate court's order.
No, no. Appellate judgment was passed in 2014 Lordship.
2014. Thereafter, the
Thereafter,
execution proceeding
execution
is
was put. We filed their petition under section 47 there,
before the executing court.
executing court. It was dismissed,
Section-
then Miss Appeal was filed,
Section
47,
47 order was dismissed.
dismissed.
Against that,
Miss Appeal was filed.
misappeal was filed before which court?
This appellate court civil judge. Civil
Okay.
judge. Now,
After
we are
that-
challenging these two before this commission.
That misappeal, against the dismissal of misappeal.
Both Lordship, both this original, this section 47 petition, rejection and Miss Appeal, both are challenging.
Both you cannot challenge.
Both are there. First one is,
This,
yes,
this application is under 227,
no Lordship, 115.
115. So which appeal, which order you are impugning?
Page 83 is the executing order. Executing court order.
In 115, you cannot
Yes,
you,
115.
you have
because-
to first challenge the appellate court's order. Consequently, but if it affects the,
Because one, is both the court's order merged together, Lordship. Both has been filed. In the cost title, we have mentioned first judgment and order dated 4/1/2024. First by the learned.
the executing court's order you have challenged
Correct.
before the appellate forum.
Appellate forum.
You are challenging this appellate forum's order before this court.
Yes.
So where is that appellate's
Appellate court order, Lordship,
at
page
Page 100.
99.
page 99? Where is the, just a minute, where is the executing court's order?
83, Lordship. Page 83, typed document.
What was your plea before the executing court?
May I please read the order, Lordship, which is there,
Yes, 83.
83.
Now, what plea you took before the, in
Same
your
is
order
this
for this?
earlier there was a suit. That is 19, title suit number 37 of 1965, the number is TS 19, number 66 of 1968. On the same subject matter.
So res judicata, it is barred by res judicata, that plea was taken.
Oh, then though you don't have a case.
No, Lordship, I have case because what I am trying to say, because of the earlier decisions, it is in respect of land. Now suit for eviction under Assam Urban Areas Land Control Act now does not lie. Land and
You
house.
took this plea before the executive.
Yes, earlier, we have said the earlier suit is PS 37 of 1965. They did not exhibit those judgments before the trial court. Although they mentioned in their plain.
No, they have filed a suit for defaulter.
Yes, now.
So
Maybe,
we are considering that suit for defaulter. In case of defaulter suit, as and when you default, they can file suit. Suppose
in respect of house, if I am a tenant in respect of a house, then this it applies. But if I am a tenant in respect of a land, where earlier in the 1965 itself, I claimed protection under this 1955 Act, and court also held that it was a tenancy in respect of land.
Okay.
Now,
read 83.
page 83. Both sides are duly represented. Today date is fixed for passing necessary order. On hearing and perusal, it appears that the Honorable Civil Judge number 1, Silchar, passed an order on 24/4/18 in mixed appeal number 3 of 17, whereby the order dated 2/3/17 passed by this executing court is set aside, directing this court to decide the petition on all question of law after giving a fair chance to hearing to both the parties. Accordingly, both the parties are heard at length. On perusal of the CR, it appears impugned order was passed in regard to the petition number 863/10. On perusal of the petition, it appears that the petition was filed under section 47 CPC, read with section 151 of CPC 1908, whereby the JD contended that this title execution case is not maintainable in the eye of law as well as on material facts. It is contended that the execution case is barred by law of limitation, estoppels, acquisitions, misdescription, and misrepresentation of necessary facts. That it is further stated that the execution is bad for non-gender of necessary parties, as DHS intentionally did not made out all the defendants of TS number 164 of 7 to be necessary parties in this case, and also concluded that this case, and also contended that this case is hit by the principle of res judicata. Now, the point of determination is to determine all questions arising between the parties to the. This court discuss all question of law one after another. In regard to the law of limitation, it appears that the date of decree is 9/2011 in suit 21/4/2024 in appeal. The title execution is filed on 20/11/2014, and hence it can be safely concluded that the execution case is filed within the period of limitation. Now, in regard to the question of non-joinder of necessary parties, it is necessary to peruse the decree of TS number 164 2007 and judgment of TS number 164 2007. On perusal of the decree, it appears that Sri Jaganmoy Pal is the only principal defendant and the rest are performer defendants. Performer defendants against whom no relief is claimed. They are impleaded as proper parties and not as necessary parties. Their presence is required for adjudication of the matter in dispute, and in case they seek to contest the suit of the plaintiff, in that event, they are considered to be the principal defendant. In this case in hand, these 8 performer defendants did not contest the suit and hence remained as performer defendants till passing of the judgment in TS 164/2007. Hence, it can be said that this execution case is not bad for non-gender of parties, as performer defendants are not necessary parties. Now, the law question regard to law of res judicata is taken into consideration. JD raised the question of res judicata, stating that before institution of the TS 164 of 2007, there were 2 suits between the same parties and on same subject matter, that is TS number 37 of 1965, remembered as TS 66 of 1968, and TS number 112 of 2004. On perusal, it appears that though all those cases are between same parties, but not on the same subject matter. TS 37 of 1965 relates to declaration of landlord-tenant relationship, but TS 164/7 relates to the ejectment of the tenant. Hence, on the above finding, it can be said that this execution case is not barred by res judicata. In conclusion, it can be said that this execution case is not hit or barred by any law in force. So that is the order, lordship. My submission is that TS number 37 of 1960, but it is the same land. That's why in the schedule of the plaint also, they have given the schedule of the land. And in their plaint, lordship, if I may take a lordship, the plaint. Page 18.
Yes,
Paragraph 2, lordship. That the page 19, paragraph 2. That the predecessor of the plaintiff and the pro forma defendants, Rajendra Chandra Pal and Jatendra Chandra Pal, were two brothers. They were owners of the land described in the schedule below by right of purchase by registered sale deed number 3406 dated 7/11/1944. The said predecessor of the plaintiff during their lifetime constructed a house over the said land, and thereafter they granted tenancy of the suit premises as described in the schedule below in favor of the father of the principal defendant, Jyotish Chandra Pal, now deceased. During the lifetime of the said two brothers, dispute arose between terms and between them, and said Jyotish Chandra Pal as tenant for which aforesaid Rajendra Chandra Pal and Jyotish Chandra Pal filed TS number 37 of 1965, renumbered as TS number 66 of 1968 against the said Jyotish Chandra Pal, the deceased father of the principal defendant number 1, before the court of the civil judge number 1, Silchar, then known as the Court of Assistant District Judge, Silchar, for declaration of the right, title, and recovery of cash possession over the suit property. That was the suit. Now, I have annexed the judgment of this TS 37 of 1965. This is page 126.
yes.
Page 126 is the Lordship, page come to please come to 132, page 132, the issue number 1 and 2. That suit was filed as we are trespassers of the land. But court said no, there is a landlord-tenant relationship, and it is in respect of land. Issue number 1 and 2, may I proceed? As the defendant number 1 to 7 are found to be still tenants in respect of the suit land, as the plaintiff's allegations of the defendant number 1 to 7 being trespassers in respect to the suit land having been not established, the plaintiffs can have no cause of action, and the suit for eviction on the ground set forth in the plaint does not lie. The fact that house on the suit land was gutted by the fire of 1954 and the defendant constructed another house on the land makes no difference, as the tenancy in respect to the land was not terminated by destruction of the house by the fire.
Okay,
So it all along in this way, it was tenancy of the land. Lordship. And the trial court also, in the judgment, it says the suit number 112.
no,
of
but this plea was not taken before the executing court.
it was taken by as a res judicata, subject matter same. Subject matter is the same.
Res judicata is a different matter, but you did not took that plea that in the present suit,
Yes.
it is under 1972 Act. And
In
the-
argument, it was made, Lordship. In even before executing court, in argument, it was.
from where we will find out.
Yes, we have annexed to.
Then what appellate court also,
Same, their appeal was dismissed, even before the second appeal also dismissed.
no,
This part was not,
in the first suit,
in the first suit,
in the
1965?
in the instant suit against the order of the
Which one?
executing court, you
Lawsuit.
filed a misappeal.
lawsuit.
In the
After-
misappeal, the court only dealt with res judicata
Before-
issue.
They were discussing only the rent control part. They were discussing as if. it
But
was
whether
suit-
you took the plea or not,
Yes, this,
where, show me your memo.
because
of appeal.
suit was dismissed ex parte. Suit was dismissed ex parte. It was from the judgment is clear, it was dismissed ex parte actually. In the appeal. And in this justice lordship, I have submitted a judgment. Kindly have a look it for a while. Look for it. Is it
No,
Calcutta?
before judgment, you
No.
clear the facts.
Yes, because these facts will, it will help lordship in these facts. Lordship. That's why I am submitting it.
No,
What-
Mr. Purkasta,
Because if it is
your,
non-executable, if the decree is, what I am trying to say, even if it is earlier not raised, if it is raised now, then decree is a non-executable
why decree is non-executable?
because rent control does not lie. Even the plain says a suit land lordship, plain is also suit land. And rent control, urban areas rent control, who is a tenant in urban areas rent control? Definition, may I please read lordship, F, which is.
No, but these things have you stated before trial court or appellate court?
Even if the point of earlier suit was taken. Point of earlier suit was taken, and earlier suit from the judgment shows it is in respect of land. And even if I have not raised, lordship, my humble submission would be in a section 47 petition, I am not precluded from raise it, and
Ah.
even before your lordship, I am not precluded.
No, but have you raised in your section 47 petition?
Yes, in argument, section 47. Page 80 is my written argument and page 75 is the petition.
No, in the 47 petition, have you mentioned that?
In it is page 75, lordship. In real facts, I have stated. That the JDC Jagannath Pal with his family members as well as other defendants of TS number 164/2007 have been in continuous and uninterrupted physical possession of the suit premises, including other land houses premises by right of inheritance from their respective predecessor. That father of the JD since deceased Jyotish Chandra Pal had constructed residential and shop house over the suit land and address and other land since more than 60 years back. That after death of his father, JD C. Jagannath Pal always done construction and renovation work of the suit premises, which was never objected to carried out by the DH or his predecessor or successors. That the DH or his predecessors were not the landlord of JD of holding the suit premises and stands in the name of father of the JD, and the JD has been paying holding tax to the Silchar Municipal Board, Silchar. So earlier position that it was in respect of land, it was stated, and in the written argument, which is page 80. Those 1955 Act has not been spelled out, but all facts have been stated. Page 80. If I may read, lordship. that the respondent being the plaintiff instituted title suit number 164 of 2007 against the appellant and 8 other persons. In the plaintiff PS number 164 of 2007, the respondent plaintiff stated inter alia paragraph that the father of the respondent, father of the appellant had previous litigation over the same subject matter of suit property by TS number 37 of 1965, renumbered as TS number 66 of 1968, SA number 105 of 1973 of Guwahati High Court, SA number 160 of 1981 of Guwahati High Court, and finally the father of the present respondent lost earlier suit in SA number of the Guwahati High Court. That in spite of dismissal of earlier suit instituted by father of the respondent in said SA 160 of 1981 by the Honorable High Court, the present respondent once again instituted TS number 160 of 2007 on the same subject matter, earlier suit against the appellant and others, which is barred under the principle of res judicata under section 1908, 11 of CPC 1908, as well as the law of limitation. The Honorable Apex Court in civil appeal number such and such.
Yes, Mr. We're issuing notice.
My lord, your lordship has seen the petition that they have filed under section 47. Nowhere, my lord, they have stated that, my lord, the suit, earlier suit and this suit, my lord, it was filed under 55 and this is 52. They are protected under 55. So the decree passed by the trial, the appellate court is nullity. No which part, nothing, my lord. Only point they raise that it is barred by res judicata.
Because in the earlier suit, there is an observation that the tenancy was in respect of land.
No, my lord. No, my lord.
There is an observation.
My lord, no. Your lordship kindly come to the judgment which he has referred, my lord. Page
No, Mr.
132.
Sen,
132.
no. We are calling for the records. Let us go through the record.
My lord, the court says that there is a relationship of landlord and tenant in respect of the suit premises. Now, suit premises, my lord, Assam type house as well as the shop, my lord, which is standing upon the land.
That is not schedule mentions in this case, schedule first mentions about the land
As well as the Assam type house, my lord.
standing thereon.
Yes,
So
and earlier suit,
that has to be examined.
Why
In
I
earlier-
need to be evicted from land if
my,
I am not a tenant of land?
my lord, land was not given on lease, my lord.
Okay.
Suppose-
Heard Mr. S.D. Purkas, learned counsel for the petitioner. Also heard Mr. B.K. Sen appearing for the sole respondent.
Notice has been issued earlier, lordship.
Notice
Footage
issued,
for
my lord.
admission.
Sole respondent, my lord.
The perusal of the case record of which is the perusal of the case record of misappeal number 9/2019. Would be necessary for consideration of the instance civil revision petition, hence call for the same. Registry to issue requisition for the said case record. List this matter after 3 weeks from the date of this
My
order.
lord, lordship may fix a date, but
Yes.
otherwise the execution case is pending
Yes,
since long.
I'm fixing a date. Let this case be listed again on 20 September. 20 September. So the interim order shall continue till next week.
Obliged.
Lordship, my lord has, my lord, likes to peruse the LCR, my lord, all right. But prima facie it appears, my lord, they have no case. My lord.
Okay, on 20th September we'll
Fine.
consider.
I am obliged. May I please your lordship? Well, on the other day, I submitted the case to the, well, I am recently engaged in the case. But on perusal of the record, I found that there are some IA in the settlement. Some of the appellant died. Respondent also died. And one petition for impleadment also pending.
It is impleadment pending.
Pending.
Huh.
One of my
At the second appellate stage, whether it is
Well,
permissible. as
exactly,
per the
some petitions are pending.
In
And-
this RSA,
Yes.
RSA applicant pending, but that is not maintainable.
Maintainable or not
let him
maintainable.
submit.
That is another aspect, lordship. And-
let him submit.
Lordship,
Complete.
lordship, I'm sorry.
IA number 4314 of 19. File to implement.
No, but at this stage, can we not go through the materials to see whether substantial question of law is there or not? Suppose there is no substantial question of law. Whether any purpose would.
My lord, suppose your lordship is going to dismiss the appeal. Suppose,
Yes,
and in that case, the
without hearing.
without hearing the petition for substitution also pending.
Substitution of the appellants.
Yes. Appellant, respondent,
Okay,
appellant, advocate for the appellant,
yes,
respondent number 1 expired. My lord, may I pray that the
Legal yes already
May
record.
may I pray that the it may be taken up on some other day.
Respond, that has already been taken care
Because
of by.
there are so many IA and other things.
no, if there is a bar, your submission is correct that without impleading the legal heirs of the appellant, we cannot hear this matter.
Of course.
All respond by one
Because
expired. I will
they will be,
inform, but
they will be affected and the decree will be executed. And then there will be a multiplicity of.
Yes,
proceedings.
yes. In which case, impleadment is still there. Who? Let us make it clear who is to be impleaded. Who?
One IA 4314 of 2019
4314.
for implement. Okay, good petition. I think. 4314.
Mm, 4314 is filed for whose impleadment?
Is implement of
Because there are 29, eight appellants. In this case, there are 8 appellants. Who has died?
the implement petition is by by the other person. My
Who filed this impleadment petition?
implement petition filed by the heirs of
Respondent.
filed the impede,
new party, lordship, the newly
came before the court filing an application for impleadment, but whether they are necessary at this stage, second appeal stage, already should decided by two courts.
I am reading the appellant's, date, date one late. Because this petition was filed by,
Now, who is appearing for these applicants? You are appearing for impleadment.
Lordship, we have filed I lordship for implement of as a respondent lordship.
Who are you? Who are these Julia Khatun, Rulia Khatun, Jaheda Khatun, Mazeda Khatun, and Sajeda Khatun? Who are they?
Lordship, my senior like another court lordship.
Yes, Mr. Bordhuya. You have objected to this.
Impleadment, I am objecting, and regarding my learned senior, respectful senior, made submission, some person respond about appellant one expired, but her sons already record their appeal number 2, 3, 4, 5, 6, 7. They are already on record.
No, the last order was that this application shall be considered at the time of admission of the connected regular second appeal. Assuming that the appeal is not admitted, then whether would there be any necessity of
Then
considering this?
they are not.
minus what I think that if the party who wants to implead in
That
this
has to be
case
decided.
has to be decided whether, otherwise, suppose my appeal is dismissed. The execution they cannot proceed. Because they will come in the execution case. Who decide whether they are necessary party or not?
Then let us decide this impleadment application. Because this has to be decided. Your senior is not there. Okay, then let us fix it on some other day.
Okay.
We'll decide in main appeal likhibo. Heard Mr. A.C. Sharma, learned senior counsel assisted by Mr. G. Bhad, Mr.
And
Brahma.
N. Brahma, learned counsel for the appellant. Also heard Mr. F. U. Bordhuya and Mr. K. R. Padgiri, learned counsel for the respondents. Also heard Miss J. Akhtar appearing in for the petitioners appearing on behalf of M. Khan in IA number 4314/2019. Learned senior counsel for the appellant submits that before considering the question of admissibility of the present regular second appeal, the impleadment petition filed by some of the applicants in IA number IA Civil 4314/2019 should be decided first. Otherwise, he submits that in case of dismissal of the appeal due to non-admission, the decree holder may face difficulty during execution proceeding, and the petitioner of the impleadment application would then no, it was petitioners of the impediment application, what they will do? They will, what is your submission?
They will appear before the court and submit their case.
No, not today. We are fixing a date. You come up. On next date, we'll discuss it. Correction होगा थोड़ा. This court is also of the considered opinion that before deciding the question of admissibility of the present appeal and before deciding the question as to whether there are any substantial question of law, the prayer for impleadment, the application for impleadment filed by some of the petitioner in I number 414314 needs to be decided first. Learned counsel for the parties submits that some prays for some time to make submissions on the impleadment application. The prayer is allowed. When will you?
Well, in this, in the month of September, 10 September or 9 September.
Let this matter be listed again on 9th of September 2024. On 9th September, we will first
Monday.
dispose the impleadment application, then because impleadment notices need not to be served.
No, need not. They serve the copy on this.
We can immediately hear after, if impleadment is allowed, we can hear the appeal. List the case accordingly, list this appeal accordingly.
I'll do it.
कि तू खामोद बढ़ाई इनके तार लगा खामोद बढ़ाई में चंबड़ नहीं बस खाली सॉरी पैकेट ऑफ बढ़ाई दे. Yes, Mr. Munir. What is this?
The transited metal lordship, the recovery of ganja was 20 kg 400 grams lordship. And thereafter lordship.
How much ganja?
20 kg 400 grams.
When were you arrested?
Lordship arrested on 11/1/2023.
What is the period?
Days lordship
Not in days,
582
in
days and lordship 1 year 7 months 23 days.
What is the stage of trial?
Lordship will kindly see the charge sheet was submitted on 28/2/2023. Whereas 8 numbers of PWs were there, lordship. Charge was framed on 7/7/2023, lordship. And till that, lordship, in the month of May, lordship, PW1 has been examined, lordship.
What is your submission? What is your
So the incursion long incursion of the out of 8 PWs, lordship, only one has been examined till date, lordship. And lordship till date, lordship 1 year 7 months 23 days, lordship. And the quantity also, lordship, little bit then lordship that 400 grams.
Yes, Mr.
Lordship will kindly see the last order, lordship. Also for that we have taken time, lordship. last order and PWD for that, last time. 6-8 Lordship, here also date was there and work code also Lordship. So the adjournment was short to.
Yes, Mr. Bosho.
My lord, earlier this petition rejected on 11/12/2023, Lordship, with a direction to expedite the trial. And after 11/12/2023, my lord, there is the matter, it came up before the.
What was the bail application?
That bail application number
11/12/20,
4028 Lordship. I have annexed Lordship, page 27.
page 27, it is already annexed.
What was the direction? Easily.
Direction was, my lord.
So expedite.
Expedite.
Uh,
Page
Lordship,
29.
an observation is made hereby that the learned trial court may take steps to expedite the trial of the present petitioner and disposes of the NDPS case number so and so as early as possible.
As early as. Okay. Now they are behind the bar for 1 year, 7 months. Then which judgment you are relying? Which authorities you are relying? You are relying. Why should you be given bail?
Due to the last Supreme Court judgment. Lordship,
Which judgment?
the judgments were. Lordship, I did not brought it, Lordship, because Lordship, I fixed it too, Lordship, I'll put it.
No. You should have brought it. Heard Mr. S. Munir, learned counsel for the, Mr. Bosho, any submission?
My lord, my submission only that part that my lord is earlier it is rejected on 11/12/2023, and after that, my lord, that is 7 dates came before the learned trial court. That is within 6 months, and on the that is the 7th of that date, 21/5/2024. That is already been submitted. That 1 PW was examined.
Ms. Munir, learned counsel for the petitioner, also heard Mr. K. Bosho, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973 has been filed by the petitioner, namely Muhammad Saidul Ansari, alias Sadul Ansari, who has been detained behind the bars since 11/1/2023, within bracket for last 1 year, 7 months, 23 days, in connection with NDPS case number 62/2023 under section 20B2C of the NDPS Act, 1985, pending before the Court of London, Special Judge Kamrup Metro. Where is the earlier rejection order?
Page 27, Lordship.
The gist of accusation. In this case is that the petitioner is facing a trial under section 20B2C of the NDPS Act, 1985 on accusation of possessing 20 kg, 400 grams of ganja and ganja stop. The petitioner was arrested on 11/1/2023, and since the date of his arrest, he is detained behind the bars. In this case, the charge sheet was laid against the petitioner under section 20B2C of the NDPS Act, 1985 on 28/2/2023, and thereafter charge was framed against the petitioner on 7/7/2023. Stop. However, learned counsel for the petitioner submits that even after prolonged incarceration of more than 1 year, 7 months, the prosecution side has examined only 1 out of the 8 listed witnesses. And there is unlikelihood of culmination of the trial very soon. Stop. It is, it is also submitted by learned counsel for the petitioner that on an earlier occasion also, that is, on an earlier occasion also, the petitioner approached this court by filing a bail application number 4028/2023, which was disposed of by this court by order dated 11/12/2023, wherein the prayer for bail was rejected. However, while rejecting the prayer for bail on that occasion, this court made an observation and that the trial court was requested to take necessary steps for expeditious disposal of the trial as early as possible. Expeditious disposal of the case pending against the petitioner. Stop. However, it is submitted by learned counsel for the petitioner that even after lapse of more than 8 months of the said order, only 1 witness has been examined. He has submitted that the last date of the case was fixed on 6/8/2004, and on that day also the prosecution side had failed to produce any witness. Learned counsel for the petitioner has also submitted that though due to possession, though because of the accusation of possessing commercial quantity of contraband, apparently embargo of section 37 of the NDPS Act 1985 appears to be applicable in this case, however, he submits that in view of several observations made by the Apex Court of India in a number of cases, in case of inordinate delay in trial, in such cases, the embargo of section 37 is lifted and it gives way to the right of the accused under Article 21 of the Constitution of India. He submits that in the instant case also, the right of the above named petitioner guaranteed under Article 21 of the Constitution of India overrides the embargo of section 37 of the NDPS Act. Then quote para 8(9) from bail application number 3881/2023. On the other hand, learned additional public prosecutor has opposed the prayer for grant of bail to the present petitioner on the ground that there are sufficient incriminating materials against the present petitioner for possessing commercial quantity of ganja within bracket 20 kg 400 grams in this case, comma, hence the embargo of section 37 of the NDPS Act is applicable to this case, and therefore he may not be allowed to go on bail. I have considered the submissions made by learned counsel for both the sides and perused the materials available on record. Court para 17, 18, 19, 20, 21, 22, 23, 24. In the instant case, next para, in the instant case, the petitioner has been languishing behind the bar for last more than 1 year, 7 months. And in spite of an observation made by this court in bail application number 4028/2023 on 11/12/2023 for expeditious trial of the case, comma, however, till date, only 1 out of 8 listed prosecution witnesses has been examined. Hence, in view of the fact and circumstances of this case, as well as in view of the observations made by the Apex Court in the rulings cited herein above, this court is of considered opinion that due to the prolonged incarceration of the present petitioner, as well as slow progress of the trial pending against him, the fundamental rights of the petitioner guaranteed under Article 21 of the Constitution of India outweighs the embargo of Section 37 of the NDPS Act, 1985 in this case. And therefore, Therefore, the above named petitioner is entitled to go on bail. In view of above, the petitioner, namely, what is the name?
Saidul Ansari.
Saidul
Alias
Ansari,
Sadul
alias Sadul Ansari, is hereby allowed to go on bail of rupees 50,000 with one surety of like amount. Subject to the satisfaction of the learned special judge, Kamrup Metro, Guwahati, with following conditions. Conditions, it's saying.
Conditions may be there, my lord, because the accused petitioner, he is from outstate, from Jharkhand.
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 Then what is the assurance that he
Government,
will raise the bail amount or two sureties?
sorry,
With-
one would government surety that can be lordship. As lordship, please, lordship, because he is outside the lordship. That is-
50,000 with two sureties of like amount. With conditions 1 to 6. Conditions are there. With above observation, this bail application is hereby disposed of.
Much obliged.
Item number 11. Item number 11, my lord, in item number 11, I have served a copy to my learned friend today. He has entertained evidence today.
Item number 11.
11.
Okay.
So, my lord,
My submission to be lordship. It is a case of 2000 trial. I am a landlord. I have filed a suit for ejectment. Suit was decreed in my favor. Thereafter, lordship 2008. Thereafter, lordship first appeal has been filed. First appeal by the tenant that was dismissed. Thereafter, Lordship, CRP has been filed before this honorable court. CRP has also been withdrawn with liberty to file second appeal. So my submission to be, Lordship, this is a case of 2008. Lordship may fix the case any other date for disposal, Lordship. Because, Lordship, my client is not receiving anything. So he will argue the case regarding admission, Lordship. I will argue the case, Lordship. So Lordship may fix this matter for a final disposal. It's a 2008 matter.
No, how it can be for, if suppose there is no substantial question of law, then it will be
Yes.
finally disposed of.
Lordship. It is a
If
second-
there is substantial question of law, then records have to be called for.
Lordship.
So it has to be only
Lordship,
adjourned.
Lordship is aware that under Urban Area Rent Control Act, there is no provision of second appeal. That has been decided by the Honorable Supreme Court and this court time and again. In Urban Area Rent Control Act, there is no provision for second appeal. So law has been settled by this court and the Supreme Court. So this is a case of Urban Area Rent Control Act. That is why I am submitting. He will argue this case, Lordship.
Then on
That has to
admission
be
date,
already
you may
decided.
make the
Lordship,
submission.
that is why, Lordship.
We have not challenged that order.
Okay. Heard Mr. P. Upadhyay, learned counsel for the appellant. Also heard Mr. S. K. Goswami, learned counsel for the respondent, who has made his appearance today only. Today,
Lordship, today he has given the copy. As
copy
directed by
of
the-
what?
Copy of the appeal memo and stay petition.
Okay, so difficulty, you have difficulty today.
He has difficulty.
Okay. Who has submitted that as he has been furnished with the copy of memo of appeal as well as annexure today only. He needs some time to go through the same and prays for an adjournment. Prayer is allowed. Let this matter be listed again on which date?
As per Lordship decision. Lordship.
After 2 weeks.
No,
on
no,
it,
no. There is some urgency, 28 of this month.
28 August 2020.
Obliged.
Matter.
Register AG may can be seen. Because some of them have received through register AG.
Unserved notice. Respondent number 4, unserved notice. Respondent number 1, 2, 3, and 5 to 9. Neither AD card nor unserved notice are returned.
Register notice, my lord, none of them have received it.
Uh-huh.
So
That
my,
is-
my humble service would be that, my lord, and let me serve the notice to substitute the body newspaper, because they do not receive it. So
No.
later, let me serve the notice to
Not
the
now, not
Assam
now.
Tribune, Assam Tribune.
No, not now. After you take steps
I will
as,
take steps, besides that,
no,
besides
no,
that.
not beside that. If the steps, notices are issued, is served through usual mode, then where is the requirement of substituted service?
Because again, they.
Let us wait for one day. Let us see that whether it comes or not. Otherwise, if you fail to serve notice through usual mode, then you may pray for substituted notice. One more date. Let us be as it is.
Then, my lord, let it be within 2 weeks, because it is nearest the Rajgor, because they are trying to occupy the land. That is the conspiracy. The land is free. 2 weeks, my lord. I will take steps tomorrow, on Monday. Monday steps will be
3
taken.
weeks, 3 weeks.
Okay,
Into 3 weeks. Kori.
obliged.
Mr. Chak.
Lordship, in this case, the airport authority has their own counsel, Mr. R.K. Dubey. Just Union of India is a formal party. Let him serve a notice to
R.K.
Mr.
Dubey is also,
Standing Council of Airport
so you have
Authority of
to
India.
serve notice.
Airport Authority of India, they are the principal party.
You
Lordship.
appeared today itself.
Myself is only for respondent number 1, Lord. Union has nothing to, he has no grievance against the Union of India.
So let us issue notice as the standing councils are there. Of
Till then, if some kind of.
Let
protection is
him
there,
serve
my-
copy, let it come on Monday or.
Because the thing is that, my lord, the nature of duties which we are performing, it deals with goods of perishable nature. So tomorrow, my lord, if they put it under lock and key,
No, they cannot put you under lock and key. By
Let him serve a copy to Mr. R.K. Dubey. Let can be taken up on Tuesday or Wednesday.
on Monday, Tuesday,
Monday or
because
Tuesday.
councils are available.
Monday.
All other respondents are airport authorities.
Yes, Lordship.
Okay. Heard Mr. S. Das, learned counsel for the petitioner. Also heard Mr. B. Chakravarti
Correspondent number one.
for respondent number one. This application under Article 227 of the Constitution of India has been referred by the petitioners, impugning the order dated 1/8/2024 passed by the Court of Learned Civil Judge Senior Division number 2 Kamrup Metro in Miss J case number 703/2024 arising out of title suit number 383/2024, whereby it rejected to grant ad interim injunction on the prayer of the present petitioner.
Lordship, the order is neither rejected nor it can be interpreted as not granted, then it is rejected.
What?
Because
Oh,
only notice was been issued.
oh,
Three different orders put in one page, man.
no, rejected to Katidio. Whereby it issued notice to the respondents. But you made prayer for ad
Yes,
interim
yes.
without
Whether it can be treated as a rejection.
without stating therein anything regarding the prayer for grant of ad interim injunction made by the present petitioner. Learned counsel appearing for Union of India. You are central government.
CGC.
And its central government council appearing for Union of India has informed this court that Mr. R.K. Dubey
R.K. Dubey.
is the standing counsel of the Airport Authority of India in this court. In view of above, the petitioner is allowed to serve, issue notice to the opposite party. Since Mr.
Chakrabarti.
Mr. B. Chakravarti has appeared for respondent number one, no formal notice need to be issued. As regards other respondents, the petitioner shall serve copy of notice along with the petition, revision petition and annexures therewith to the learned standing council of Airport Authority of India, B. Chakravarti.
Mr. R.K. Dubey.
Sorry, Mr. R.K. Dubey within a period of
2 days.
during the course of the day. Let this matter be listed again on Tuesday. Tuesday is 20 August
As a motion item.
as a motion item.
Highly obliged.
Hearing Mr. Das, your other side is there.
I'm told he has some matter, he will come.
So we will take up orders first, then we will take up your item as the first hearing item. Because only limited portion is remaining. So after orders, we will take up your matter. In the meanwhile, let him come also. Or you have come,
Yes.
then you take rest for some time.
No, he only
No, let us take up orders
Orders
matter,
first.
orders first, then we will take it.
because others will be waiting unnecessarily.
Yes.
Item 14 to 21.
None appears for the appellants on call. It appears from record that on last two occasions also, nobody has appeared for the appellants. for the appellant's on call. Let this matter be listed again after 1 week on a date to be fixed by registry.
May I please, Your Lordship? Here, as per office note dated 7/8/2024, although the dusty notice have been received back by the appellant side for service, but the affidavit of service has not yet been received in the section. Your Lordship, we actually had filed the affidavit, but it is not there in the record, Your Lordship. So we may be allowed to file it again, Your Lordship. And
Miss U Chakravarti,
M. Chatterjee for you, Chakravarti.
M Chatterjee, learned counsel for the appellants who submits that the appellants have taken steps for service of notice on whom?
Your Lordship, on all the respondents.
On the respondents
Yes, sir.
through dusty mode. How, and they have also filed an affidavit in compliance. However, same is not traceable. Therefore, she submits that the appellants may be allowed to furnish another affidavit in compliance and prays for some time to do so. The prayer is, you're for?
I am for respondent number 2, Lordship.
Also, উপরত লিখিব, also heard Mr.
T.R. Gogoi, Lordship.
T.R. Gogoi appearing for respondent number 2.
Lordship.
Okay, so the prayer is allowed. Let this matter be listed again after 2 weeks.
Obliged to list. Your Lordship, here in this matter, Your Lordship, the government side, their name is not being shown in the cause list. It may be shown, Your Lordship, because service has been made to the government side. And here, as per office note dated 7/8/2024, by order dated 27/11/19, AD card of our respondent number 5 has been received back bearing signature of one Robin Chaudhary. The same is on record, but no response has yet been received in respect of our respondent number 1 to 4.
Who is respondent number 5?
Respondent number 5 is Your Lordship, is the former respondent, the government side.
Huh?
Of,
Private respondent,
private
Milan
respondent.
Chaudhary. Not
Who is Robin Chaudhary?
Sorry, I don't know that. Sorry, three, Lordship. Robindra Chaudhary, maybe. Copy now.
Respondent number 3 is Ravindra Chaudhary and 5 is Milan Chaudhary. Your Lordship.
Lordship, I am appearing for 1 to 5, Lordship.
You are appearing?
Yes,
Okay,
for
no
respondent, but we have not received any copies till
Okay,
today,
very good,
Lordship.
very good.
So copies may be provided to us, appeal and miss case also, in both, Lordship.
What is the miss case?
Your Lordship, it is for staying of this impurity.
Heard Miss
M. Chatterjee.
M. Chatterjee, learned counsel for the appellant. Also heard Mr.
M.J. Gogoi, Lordship.
M.J. Gogoi, who learned counsel for the respondent number 1 to 5. No one has appeared for pro forma respondent. Learned counsel for the appellant has submitted that they have served notice on respondent number pro forma respondent. However, as the name of government counsel is not reflected in the cause list, perhaps therefore nobody has appeared. Stop. The registry is directed to reflect the name of government counsel representing the pro forma respondent in the cause list henceforth. Learned counsel for the respondent has submitted that they have not been furnished with the copies of memo of appeal as well as the interlocutory application, which the learned counsel for appellant undertakes to furnish today itself within a
Within a week, Your Lordship.
within
2 or 3 days. Your Lordship.
within 2 days from the date of this order. Let this matter be listed for admission hearing.
Yes, Your Lordship.
for admission hearing after 2 weeks.
Obliged.
I'm appearing for the respondent's lordship, number 7A, 8A, B, C, D, E till F, 9A and 12A, B, C, D.
None appears for the petitioners on call. Heard Miss
M. Devi lordship.
M. Devi appearing for respondent number
Respondent numbers 7A,
7A, 8A, 8B, 8C, 8D, 8E, 8F, 8, 9A,
9A.
12A, 12B, 12C, and 12D. It appears from record that on last 2 occasions also, none has appeared for the respondent side. What is the matter?
Lordship, the execution proceeding has been stayed, lordship. We have filed an application for stay of the execution, lordship. That application was rejected. Against that, they have approached this honorable court.
In this case, there is no stay.
There is a stay, lordship.
In this case also.
Yes, that order of rejection, lordship, that was stayed.
Order of rejection was stayed.
Lordship.
That means it was allowed.
No, lordship, the execution was stayed. I'm sorry, lordship, the execution was stayed.
Okay. By which order?
Lordship, by order dated 15/9/17.
Since nobody has no one has appeared for the petitioner on last 2 occasions without any valid reason, this revision petition is dismissed for default. The interim stay granted on 15/9/2017 is hereby vacated.
Lordship.
None has appeared for applicant on call. On last occasion, also, on last date also, nobody has appeared. Stop. Let this matter be listed again after a week on a date to be fixed by registry. None has appeared for the petitioner on call. Let this matter be listed again after a week on a date to be fixed by registry.
May it please your lordship, the dusty service affidavit is on record. Also, I have been informed that the petitioner has passed away, your lordship. So kindly.
Petitioner,
Yes, your lordship.
Lordship, he is passed away on 31/7, no?
I'm not aware of the date, but kindly give us some time to file the substitution.
Yeah,
petition.
petitioner expired on Lordship 31/7/2024.
okay. Heard Miss S. Newar, learned counsel for the petitioner. Also heard Mr. N. J. Gogoi,
Lordship.
Learned counsel appearing for respondent number 1, 3, 7, 14, 15, 16, and 17. Learned counsel for the petitioner submits that as regards respondent number 5 is concerned, the petitioner has taken steps for service of notice through Dasti mode and has furnished affidavit of compliance. What is the name of the petitioner?
Mohammed Shahed Shah.
Rahan Shah. Who has sworn the affidavit? Advocate's clerk. Okay. No, but there is no signature of.
Your Lordship, the Dusty was filed by the clerk who had served the notice, Your Lordship.
No, but where is the proof that
It is in a signature is required.
you have to take fresh steps?
The petitioner expired as per my telephone instruction on
No.
31/7.
Petitioner has expired on 31/7.
As
Who
per-
took these steps?
He was bedridden for quite some time, so over the
Who served the notices to the respondent
number
number 5?
clerk, Lordship,
Clerk.
clerk.
He didn't took the signatures. That,
Only the received signature he took. Your
where
Lordship.
is the received signature?
It is part of the affidavit, Your Lordship. Annexure 1, Your Lordship.
No, but his name, it is not legible. No money.
Nauman Shah, respondent number 5, Your Lordship.
Okay. On perusal of the affidavit furnish of compliance filed by one Mr. Ratul Kumar Burman, advocate's clerk for the petitioner side, it appears that the notice issued to respondent number 5 was served by Dasti mode on him on 16/7/2024. The signature of the appellant appears to be, the signature of the respondent number 5 appears to be appended in the copy of notice annexed with the affidavit. Hence, the notices are deemed to be duly served on respondent number 5. Learned counsel for the petitioner has also submitted that she has come to know that the petitioner has in the meanwhile passed away on 31/7/2024. And she prays for some time to take appropriate steps for taking steps regarding substitution of the petitioner by his legal heirs. The prayer is allowed. Let this matter be listed again after a period of 2 weeks on a date to be fixed by registry.
Bless.
Next page, Your Lordship. I have filed a IA, my lord, for release of 1,25,000. And subsequently in pursuance of the court order, my lord, and this same, my lord, order dated 30/7/2019. We have received the amount of 1 lakh and remaining 25,000, my lord, the learned claim, my lord, Mr. S. Doctor, stated that, my lord, it is adjusted with the statutory money or not. It is to verify, my lord. And And therefore we are seeking time, my lord.
Oh, you need time.
Yes, my lord. Further 2 weeks time may be granted.
Heard Mr.
Here, but my lord.
A. R. Padgiri, learned counsel for the applicant, also heard Miss
Yes,
What?
Musahari, my lord.
S. Mushahari, learned counsel for the opposite party / insurance company, who prays for some more time to take instructions regarding the question whether the statutory amount of rupees 25,000
Adjusted with the my lord.
No, as per direction of this court's order, 1,25,000 was deposited.
Deposited, my lord. I have
And
already received
whether
1 lakh.
25,000 extra was not deposited,
Not to be- That,
that has to be found.
my lord, verify.
Whether statutory क्या लिखा?
Adjusted or not.
Is
Adjusted.
adjusted or not. Prayer is allowed. Let this matter be listed again after 2 weeks.
Obliged.
Obliged.
May I please, your lordship? Lordship, as per instruction of my senior, Mr. Arsipal lordship, his name has been wrongly reflecting in the IA petition for restoration and the delay lordship. Because in this case, I have not filed Ukalatnama lordship.
What is, whose name?
Mr. Arsipal lordship, respondent number 1. He has
Okay.
not filed the Ukalatnama in this case.
None appears for the applicant on call. Mr.
A.R. Das.
A.R. Das, learned counsel, appears and submits that the name of his senior, Mr. R.C. Paul, has been wrongly reflected in the cause list as counsel for the respondent. Stop. He further submit that the state council has not submitted any wakalatnama and therefore prays that his name should not be reflected as counsel for the respondent in the cause list henceforth. Prayer is allowed. The name of Mr. R.C. Paul should not be reflected by the registry in this case as counsel for the respondent henceforth. List this matter after a week.
Matable.
May I please, your lordship? Lordship, IA 2388/2022 has been filed for substituting the legal errors of appellant number 1, lordship.
Yes. When appellant 1 died,
1/9/2020.
when have you filed this application?
Lordship, there was a,
Is there any delay? No. No.
no, lordship.
Okay. Heard Miss, what is your name?
F. Ahmed.
F. Ahmed. You are appearing for?
K. Kolita on behalf of NDE.
For?
NDE. Lordship.
Now for respondents,
For respondent, Lordship.
all respondents,
All the respondent.
also Mr. K. Kolita appearing for Mr. N. D. Learned Counsel for the respondents. This application under Order 22 Rule 3 of the Code of Civil Procedure, 1908 has been filed by the file praying for substitution of the legal heirs of applicant number 1, namely, what is the name?
Lordship Safikur Rahman Lashkar.
Namely Safikur Rahman Laskar. Stop. Learned Counsel for the applicant submits that the applicant Safikur Rahman Laskar had expired on 1/9/2023-22, and this application has been filed within the period of limitation. It has prayed for substituting the names of whose names you want to substitute?
Lordship,
Who are the heirs?
Lordship, the widow and 3 sons. That is in page number 8, Lordship.
Learned Counsel for this petitioner submits that on death of Muhammad Safikur Rahman Laskar, his widow, namely Husna Begum Laskar, and sons, namely Arif Ahmad Laskar, Tarif Ahmad Laskar, and Sharif Ahmad Laskar, may be substituted in place of applicant number 1 as applicant number 1 within bracket A small a, 1 small b, 1 small d, and 1 small d respectively. The Learned Counsel for the opposite party respondent does not have any objection.
Lordship, I want to correct one thing here. Lordship, I am for the respondent number 1. which,
Okay,
Hafiz
respondent,
Hussain Laskar.
respondent number 1. Considering the submissions made by Learned Counsel for the petitioner as well as facts stated in this application, the prayer is allowed. Let the aforementioned legal heirs of deceased applicant number 1 be substituted in the CRP case number 57/2020 in place of applicant number 1. Registry to make necessary corrections. Registry to insert the names of substituted applicants and list this matter again after a week. What is this?
The application for conversion of delay in filing revision. In this case, my lord, ex parte decree was passed against my client.
Okay.
Against the petitioner, ex parte decree was passed. Thereafter, he had
When?
applied. Ex parte decree was after he had applied for vacating ex parte decree, and that was refused. Against that, he has filing appeal.
Okay.
Against vacating ex parte decree, against the refusal of vacating ex parte decree, he has filed an appeal. The appeal was also dismissed. Thereafter, the advocate had carried out the petitioner approach to the advocate in Guwahati. And the advocate at Guwahati had filed a SAO, second appeal against order.
Order.
Actually, second appeal does not lie in this case. In this case, there will be a revision. So perhaps because of that reason, the advocate has specially filed the second appeal SAO. Thereafter, he has withdrawn that.
He has withdrawn.
Withdrawn that without any instructions to the
of the petitioner is withdrawn, and even after withdrawal of the appeal, he did not inform the petitioner. The matter remained there. The petitioner, from time to time, petitioner gets information about the appeal. The advocate informs him that yes, your appeal is pending. It will be decided. At last, in the year 22 also, after lockdown, in the meantime, there was lockdown period. So in the lockdown period also, after he informed that good information, the advocate said after lockdown, it will be listed. After lockdown, the petitioner came to Guwahati to get information of the appeal. The advocate said that yes, your appeal will be listed within 2 or 3 days, 2 or 3 months, it will be disposed of. The petitioner wanted to know the case number, it was not supplied to him. He wanted to take the copy of the appeal, it was not handed over to him, it was not supplied to him. At last, the petitioner contacted another advocate. So what is the matter? This is the proof. So when the another advocate had seen in the court system, it was found that the said appeal, SAO, had been dismissed on withdrawal on first hearing of the case itself. But the advocate continued to tell him that the case is pending. Even the petitioner had recorded the conversation between him and advocate.
Whether have you filed any complaint against the
That complaint has been filed to the Bar Council of India. Complaint has been filed to the Bar Council of India. Let us see the matter. Why not you kindly see them? A very unfortunate incident. And he has been told that appeal has been admitted. So after admitting appeal,
How much is delay?
it will, after admitting appeal, it will take 8 to 10 years, 9 to 10 years after admitting appeal. So you need not take information about the matter. It will take 10 to 11 years after hearing of the appeal, after admission of the appeal. So till then, if anything happens, you will get informed. That is usual practice, pilot. That is usual practice. An appeal is filed after admission of appeal, it will be kept there pending. And if anything happens, the advocate will inform the client. That is the main situation. So my lord, may kindly see that application for condition of delay. Very unfortunate incident, my lord. My lord, annexure number 1 of the petition, my lord. Page 13. Page 13. Looking back, 14/8/11. Heard Mr. A.K. Gupta, Land Counsel for the appellant, who seeks to withdraw this appeal. In view of the appeal is disposed of on being withdrawn by the appellant, considering the request made on behalf of the appellant, they are allowed to file fresh petition in future if so advised. So this was the order. Thereafter, we do not know what has happened, whether the appeal advocate forgot about the matter or what transpired. We do not know. He did not inform. So later on, we have obtained certified copy in 22 of about the appeal, because the record was not given. He has not supplied us even the copy of the appeal. So it was obtained, certified copy was obtained by the petitioner on 22/6/22 about the appeal. Even the advocate to whom he has shown the matter, he was also under the impression that so perhaps after withdrawal of the appeal, he has filed revision petition. But unfortunately, that was not done. So they have obtained in June 22, and thereafter they have obtained certified copy of the order also. And my lord, we have also enclosed, my lord, the telephonic conversation. Page 23, my lord. We have called upon them. They are calling upon him. He was not there. Not correct. Phone not connecting. Sometimes phone is not connecting. Maximum times phone did not connect. We called them, phone did not connect. How many phones is my phone is not connecting? We do not know whether he has blocked or something else. Then he has made message also. Page number 28 message was there. केस 28 सर हम लोग को केस रजिस्ट्रेशन नंबर भेज दीजिएगा प्लीज प्लीज सर प्लीज सप्लाई द केस नंबर the next then the advocate replied that he will send the case number, but presently he is not at Guwahati. My lord is found it, my lord. Case 28, my lord. Case 28, my lord. My lord, long back in 2011, he has withdrawn the case. But what he is writing to his client, my lord, case handler, sir. Client has searched the case number. He said, I am not in Guwahati. आके दे दूंगा. I will supply it. Sir, coming to Guwahati. Thank you, sir. Sir, I quote our case registration number दीजिए please. Please urgent. He is searching the number registration number. That is not supplied. Immediately Singhi was the registration number. Then he personally came to Guwahati. The client has personally come to Guwahati. And in the opposite party has submitted their affidavit of opposition. Against it, we have filed our affidavit in reply also. And affidavit in reply, we have submitted our case which we have filed in the Bar Council of India. Against the
Where is the complaint?
you know, that is in affidavit in reply, along with my affidavit in reply. Affidavit in reply, page number 14. I don't got it, my lord.
Okay, okay.
Okay.
How much delay is there? Many, 10 years.
That was in 2011, my lord, but my lord may see that what the litigant will do. He had given the case to one ago. Advocate filed the appeal. Thereafter, advocate perhaps found that appeal is not maintained.
What is the matter? What was the dispute?
My lord.
What is the matter?
My lord.
Dispute? What?
Regarding landed property, regarding one land. It is very unfortunate. From starting, it has been somehow ex parte decree was passed against me without, we have no.
You are
notice.
in possession
We have.
of the,
My lord.
you are in possession of the land.
Still, I think we are. I think we are. Still execution was not.
My client.
Still, I do not know. I have to.
You are in possession.
I have to get information. He says, if he says his client is not, that maybe I have to get information. But problem is that, my lord, how unfortunate incident it can be.
When you came to know that your first appeal was dismissed, and when you came to know?
That is all information here, my lord.
Which date?
Which is page number, my lord, you may kindly see. My complaint, my lord. Therefore, after filing the bill, petitioner used to keep track with the advocate, AK Gupta and said, used to tell him always that the matter is pending and to be listed in due course of time. And early hearing can be allowed only in very rare and urgent matter. He also told that appeals usually come for hearing after more than 10 years of filing. In the meantime, there had been lockdown since COVID-19 since March 2020, followed by limited functioning of court, which continued till February 22. And thereafter, the functioning of court was slowly going towards normal. Since already more than 10 years has passed, as advised by his advocate, and period of lockdown was over. As such, petitioners approached to their advocate through son of the petitioner number 1, namely Deepak Kedia.
So you came to know on 31/5/2022.
No, 31/5/2020, he contacted advocate, or that he had contacted advocate. Advocate not presently. He just said that yes, it will be done. It will be done. Only that is that it will be done. Your case will be heard. And even pilot can see that. Acha. Again, Deepak Kedia come to Guwahati on 30/5/22 and he met his present advocate on 31/5/22. The present advocate obtained status of SAO number from High Court website from case status. After assessing the case in the name of party and found that case had been dismissed on withdrawal by order date 24/8. The present advocate advised the petitioner to contact his advocate for the reason that after withdrawal of the case, his advocate might have filed another appeal or revision of petition. So he approached to the present advocate. The present advocate seen the status. So withdrawal was there. So the present advocate advising that after withdrawal of the case, he might have filed some appeal, revision, etc. He might have filed revision because nobody can think that he has kept the matter pending and telling the client that yes, your case is pending. That is why several times petitioner called upon the advocate, but not willing to give case number one. Sir, petitioner, a simple innocent villagers, they have handed over the entire brief of the case to the advocate, including all originals, and did not have any single paper regarding the case. From WhatsApp messages by Deepak Kedia to advocate, it appears that on 22, 26, 5/22, 26/22, or 4/6/20, petitioner continued to ask the case number. Till 4/6/22, he continued to ask the case number, but case number was not supplied to him. That ultimately, with the help of one advocate's clerk, petitioner had on 6/6/22 obtained certified copy of order dated 24/8/11. On 6/6/22, he is obtained certified copy. The process of obtaining copy had taken some time, extra time, because it was not made online as informed by said clerk. At the relevant point, orders were not made online immediately. Along with the certified copy of the son of the petitioner was reached to the advocate A.K. Gupta on 7/6/22 and inquired as to why he had withdrawn the case without any authority from his father and uncle who were the appellants, as to whether he has filed any other appeal or revision after withdrawal. Very surprisingly, Advocate A.K. Gupta has shown his complete ignorance about order dated 24. He is shown complete ignorance. He says, I do not know what is the order of the day. He is shown his complete ignorance. And the order says that he had known it. He shown his complete ignorance. And according to him, had never withdrawn the case. It is worth to mention that during entire conversation with him prior to showing the certified copy, that he continued to say that case was pending, and after showing order, he continued to plead ignorance. So on that day, when the petitioner met him, initially he did not show him certified copy. He asked him about the fate of the case. He continues to say, yes, your case is pending. It will be very shortly, it will be listed and will be disposed of. And as the petitioner has obtained certified copy, he has recorded his voice conversation also. We have submitted his voice conversation also, madam. Well, it is in the page number 43. Affidavit in reply, page number 43.
Okay.
These are phone conversations, recorded phone conversation, court recorded. Audio clip data 1/6/22.
In the conversation, counsel continued to assure that the
Case will be
appeal
listed.
appeal is pending.
Appeal is pending, it will be listed shortly and it will be disposed of.
Okay.
That is the main problem.
Then ultimately, when you believe that no
Ultimately,
case has,
ultimately, certified copy has been shown to him. Certified copy has been shown to him. After seeing certified copy, he says that no, I have never withdrawn the case. I do not know about the order, how the order was passed. I have never withdrawn the case. That is his main problem. So he said that he has never withdrawn the case.
okay. Now,
Till last he continued to say that he did not withdraw the case. That is the main problem. So thereafter,
what is the status of the complaint which is pending before?
it is.
EC? Are you
it-
pursuing that
Yes.
or you have
Yes,
only?
yes, no, we are pursuing that. Initially, he did not receive the notice on the pretext that address is not correct. Ultimately, we obtained the address from the bar association and bar council. We have obtained one address. On that address and phone number, we have sent the notice to him, and notice has served upon him, and it is fixed for his reply. And after submitting his reply, the case will proceed in bar council. That is fixed for his reply.
Okay, now what is your submission?
So
Now, how much delay is there?
well, delay
4,037 days.
Hello. two days. Entire portion, right? 2 days. After excluding that period of lockdown, as excluded by Honorable Supreme Court of India, it is 2 days. These are. So thereafter, he is contacted, when filed that, well, ultimately when he filed that, the advocate has not informed me, he has not even filed any other civil division after withdrawal of the case. Thereafter, the petitioner contacted the present advocate, and naturally, it took some time for the present advocate also to bring all the things, and thereafter the matter is it will be filed on 38/22. Filed on 38/22. My lord, this is. We have better, since the advocate was not returning the brief, as such petitioner had obtained certified copy of memo appeal, which it could obtain on 22/6/22. Certified copy of memo appeal. After applying on 6 June 22, ultimately after repeatedly approaching the advocate, he had returned the brief of the case very reluctantly in last days of June 22. June last month, because entire brief will be required. Otherwise, all evidence etc. will be required. So ultimately, he returned the brief in last days of June 22. After receiving the brief of the case and coming to know about dismissal on withdrawal of the case, the petitioner were totally shattered. They had gone in grave shock and were totally clueless as to what to do. Their valuable property has been almost lost due to professional misconduct of advocate. Ultimately, they have decided to file complaint against advocate before the Bar Council of India, and they have filed the complaint. Yeah. So, ultimately, they have decided to complain and decided to approach this honorable court with prayer to admit the revision petition by condoning delay, so they may not be punished for the fault of their advocate. In the meantime, there had been summer vacation of the High Court, and advocates were also not available. Summer vacation started in the meantime. 1st July, there was summer vacation. After summer vacation, the petitioner contacted the advocate on 25 July 22 because the advocate had reached on 22/7/22. From his outstation tour, the advocate had taken more than 1 month time studying the brief and drafting revision petition with application for conditional delay, and now it is filed before this honorable court. Thus, there has been delay of 3 to 2 days, which is exclusive because of fault and negligence of their previous advocate. So, my lord, very unfortunate case, my lord.
You are relying on any authority
My lord,
for negligence of the council.
my lord,
Who
exactly this type of case, that is the rarest case, this type of case cannot be found, but of course, there are many. The 2008 SCC,
page,
page 321.
how much delay was there?
My lord, in that case, my lord,
I'll go through the case
Yes,
myself.
my lord.
You just tell me how much
Yes, ma'am.
delay was there.
In that case, there was 394 days delay.
1 year or something.
394 days. And here it is very important, but very much it is made by the Honorable Supreme Court in this case, that my lord, it is also very relevant. The Honorable Supreme Court says that in paragraph number 15 and 16. Okay. Let us next also refer to some of the special factors which have a bearing on
Okay.
what constitutes subpoena court. The first is whether the appeal is pending in court where regular and periodical dates of hearing are fixed. There is a significant difference between an appeal pending in a subordinate court and appeal pending in a high court. In lower courts, date of hearing are periodically fixed, and a party or his counsel is expected to appear on those dates and keep track of the case. The process is known as adjournment of hearing. In fact, this
court in Ramsaran inferred that limitation period for bringing the legal original might have taken fixed 90 days time. The listener might have expressed, yeah, then thereafter court said that in contrast, when appeal is pending in high courts, dates of hearing are not fixed periodically. Once the appeal is admitted, it virtually goes into
Therefore, it
storage
is
and
for the council to inform the
yes, sir.
parties that your case is
Yes, yes,
listed.
yes, sir. That actually here in this case also court says that it takes almost 10 years, 10, 11 years takes for hearing of the appeal to come. In the meantime, the party has to do nothing. So whenever the case will listed or hearing, the council will inform the appellant about the case. Till that the appellant has to do nothing. So in my case also, the appellant has relied upon his counsel. That council will inform me whatever happened, and that was the instruction of the council also, that it takes 10 to 11 years after admission of appeal. So you don't worry, or if anything happens, I should inform you. I will inform you. But he is never informed. In fact, he had withdrawn the case, but never informed. That is the main problem.
Okay.
Then here it said that again important.
Okay, you need not to go through. You give a copy to me.
Definitely. Again, the decision also said that it is not the period is not concerned. Period, if the Limitation Act does not say that how much delay can be condoned. It is for the discussion of the courts considering the facts and circumstances. Yes. So whether it is 1 year, 2 years, or whether it's even 10 days delay may not be condoned. Even sometimes 10 days delay may not be condoned.
You must be able to sufficiently explain the delay.
Yes.
Yes, Mr. Chauhan.
That
Anything else?
My lord, I have a strong objection, my lord.
Thereafter, I have to reply something.
My lord. 4030.
There is admittedly a delay of 11 years.
2 months.
2 months. And
Yes.
the
And my
appellant
lord,
is attributing the delay.
and my lord, a whole submission date, he fully dependent and did for long 11 years. And from Tinsukia, the 2 petitioner, out of 2 petitioner, did not turn up or came back Guwahati, my lord, for Honorable High Court within these 11 years. Even my lord, a person from foreign country, from Canada, USA, had come if he
No, they have engaged in a council.
Yes.
And in the year 2022, their council informs them that it will be listed.
My lord, I am not for the council, my lord, but my lord, it is matter between him and his council. But why my client will suffer, my lord? If you lordship entertain such type of petition and condone a delay. And my lord,
No, you have to submit that the cause shown by the appellant is not sufficient.
Not, my lord, it was satisfactory, my lord, satisfactory, because for long 11 years, he came only in 2022. And my lord, from the order, it appears that the appeal was withdrawn on 24/8/2011. My lord, page 13 of the condonation petition. So, my lord, from 24/8/2011, he came when, my lord, after Corona period over, that is 2022. My lord, it is not believable, my lord. It is not, my lord, acceptable for a prudent man. And my lord, one more submission made by learned fellow, my lord. The telephone of learned advocate was taped. My lord, it is, my lord, offense under Telegraphic Act 1882, section 5. Unless, my lord, permitted by Government of India, Ministry of Home, nobody can tape the telephone of anybody, my lord. It is punishable.
I should not interfere, but taping of phone is different thing. Recording conversation is different. Taping phone
Same
different
thing,
thing.
recording
Taping
and
of phone
taping
different, and phone recorded. Phone recording is also evidence. if it is sent, it has to be sent to FSL for its money.
No, whether recording is, there is any bar,
Bar, my lord,
section
yes.
5 bars it.
No. But
Telephone,
tapping is
recording
different thing.
telephone is bar, my lord.
Tapping is different thing. Phone tapping it when it is done by some
Recording
somewhere in the
telephone tapping
telephone
is
exchange.
something.
The record taking done by some telephone exchange, some device is put there, but recording telephone conversation is different. It is different.
Okay, on some
My
other.
lord, I draw your kind attention in the paragraph 1 of the condonation petition. Kindly see, my lord, it is a very interesting statement. That the petitioner had filed an application under Order 9, Rule 13 of the Code of Civil Procedure for vacating ex parte degree dated 14/7/2004. So ex parte degree dated 14/7/2004. Passing title suit number 23 of 40. Next line. The said application had been registered as miscase number 35 of 2009. So not in the Honorable High Court only. Here, my lord, can you see ex parte degree when passed 14/7/2009 and his petition under section 9 and rule 2 when registered 2009. 2009. Not only here, there also. Here he is blaming the advocate. There also his hometown Tinsukia, my lord. Ex parte degree was filed on July 14, 2004, and miscase was filed in 2009. So these type of, my lord, leches cannot be entertained, cannot be, my lord, indulged. So, my lord, this petition out and out be rejected, my lord. This is apparent from their statement, their petition itself. And it appears that their petition was rejected ultimately on 23/2/2010, last line of the paragraph, first paragraph. So, my lord, all along this petitioner, my lord, not only here, there also, and such type of delay, my lord, cannot be, my lord, cannot be certain, my lord. Only, my lord, my learned friend submitted that he assumed that the revision was to be filed or was filed by learned advocate, the advocate. My lord, for filing revision, one has to come to Guwahati, swear affidavit, whether he came, nowhere it is stated that whether he has come to swear affidavit or not mentioned anywhere. Only, my lord, presumption that yes, appeal was not maintainable, so my learned advocate will file revision, which will not do. Out of two, my lord, at least one petitioner has to come to swear affidavit. And that estimate me.
No, that is not the submission. Submission is the client was not knowing what is to be filed. The advocate counsel realized that revision has to be filed, therefore he withdrew it. The counsel did not inform the client.
My lord,
that is their plea.
My lord, for a moment, my lord, my lord, suppose, my lord, he not informed, but, my lord, should the petitioner wait for 11 years, my
Yes,
lord?
that may be a.
Because, my lord, on 24/8/2011, the appeal was withdrawn.
Okay.
This is my assumption.
Okay. On Wednesday, I will pass on this.
Yes.
Heard Mr. S. Sharma, learned counsel for the petitioner. Also heard Mr. S. Chauhan, learned counsel for the opposite party. Let this case be listed for delivery of orders on 22nd August 2024.
Hello, I'm submitting a substitute citation for one is 98 Supreme Court, delay of 883 days, and the court said that the act does not say that such delay can be accepted only in the delay within a certain limit. Length of delay is no matter.
Yes, that you have submitted.
Then another is
I'll
One
go
case
through
Supreme
it.
Court that has been, another is, my lord, here a decision that where even the High Court has condoned delay of 22 years and the Honorable Supreme Court did not interfere in that. Position, Regarding approaching the court against ex parte degree, I can approach against parte degree whenever I come to know about the ex parte degree. Then if I would have known about the degree, I would not have come.
আচ্ছা,
Service upon estimate number 2 to 6 awaited, my lord. As per office note date 21/2, my lord, 24, my lord. And then it's
So what is to be done? It is in the month of February.
Yes, that may be listed before the laws in my court, my lord.
Heard Mr. H.R. Ahmed, learned counsel for the applicant. Also heard Miss
J. Sharma,
J. Sharma appearing for
respondent number 1.
respondent number 1. On perusal of the office note dated 8/8/2020, office note
21/2.
dated 21/2/2024, it appears that the service report upon respondent number 2 to 6 has not been received by the registry of this court. Stop. Though the record from the trial court has already been received. Stop. In view of above, let this matter be listed before Lawajima Court, and only after completion of service on the respondent, the matter may be again listed before this court.
Obliged, my lord.
Obligation.
Very last order for this appeal was abrogated, however, due to inadvertence, steps could not be taken, we take steps within 3 days.
Heard Mr. M. Smith, learned counsel for the appellant, who prays for some more time for taking steps for issuance of notice on the respondents. The prayer is allowed. The appellant shall take steps for issuance of notice on the respondent. How many respondents are there?
3.
Respondents by registered post with AD as well as by usual mode within a period of 1 week from the date of this order. The notices are returnable after 4 weeks. Let this matter be listed after 4 weeks.
Item 26. May I please, lord?
Yes,
Respondent, yeah, lordship.
only one respondent.
My lord, I am appearing for respondent number 1, 2, and 4, my lord. And as per order of this honorable court, my lord, 1923 petitioners have to correct the title page of the petition, my lord, and they have not correct, my
You
lord.
have not corrected. You have to. What is the error in the title page? You take steps. What is your name?
Teacher Rashid.
You are appearing for Mr. Devan.
Yes, ma'am.
You take steps, otherwise it will be dismissed for not taking steps.
My lord, it's also shown the post leads, they are appeared, respond, all the respondents.
No. Question is not of appearance. You have mentioned before the court on last occasion that there is error in the serial numbers of the
Yes, my lord.
parties, which is required to be corrected.
Stapler, I'm not picking up the-
1, 3.
Stapler,
There
I'm not picking up the-
there are 2 respondent number 3. There cannot be 2
Yes.
respondent number 3. Then
My lord, main respondents number is not there, my lord. Former respondents are written as 1, 2, and 3, my lord. And I am appearing by, on the basis of the order, my lord, online order, my lord. Last order, my lord.
Actually, you are Abul Hasimullah. You are appearing for?
I am appearing for, my lord,
You have to
Abdul
correct it.
Hasimullah and Mohiran Nessa and Saina
Heard
Khatun.
Mr. What is your name?
H. Rashid.
H.A. Rashid appearing for Mr. A.A. Diwan. Also heard Miss
R.R. Bora.
R.R. Bora appearing for the main respondent Abul Hasim Mullah alias Hassan Ali.
And for other two respondents also, my
And
lord.
for
My lord, Mohiran Nessa
Mahiran Nisa
and
and
Saina Khatun.
China Khatun. It appears that in the cause title of the revision petition, the serial numbers of the respondents are not properly mentioned. And by order dated 1/9/2023, the petitioner was directed to correct the cause title of the revision petition by inserting proper serial number against the respondents. Stop. However, it appears that same has not yet been done. Learned counsel for the petitioner has prayed for some more time to make the necessary corrections. The prayer is allowed for the ends of justice. Let this case be listed again after 2 weeks. In the meanwhile, the petitioner shall do the necessary corrections as directed by this court. List accordingly.
My lord, a copy of the petition may be served upon me, my lord. But they have not taken steps till now, my lord.
You have not served.
Lordship,
Steps taken, my lord, but notice have not been taken, my notice have not been sent, my lord.
Serve give a copy of the note. I'm not reflecting it in the oath.
Okay.
Is your lordship, the conducting counsel, Mr. J. Kalita, he had to leave the court due to some personal difficulty. Kindly adjourn the matter just for the day.
Otherwise, Lordship, the decree has been already executed.
Executed, it has become infructuous.
Yes.
But let us give one.
Lordship.
Heard Miss, what is her name? As they've learned counsel for the petitioner who submits that due to personal difficulty of the conducting counsel, Ms. Rahe Kalita, she prays for an adjournment. Also heard Mr.
S. Roy.
S.S. Roy, learned counsel for the respondent, who submits that this revision petition has already become infructuous as the decree in question has already been executed. Stop. However, considering the submissions of learned counsel for the petitioner, this revision petition is adjourned for today. Let this case be listed again after a week on a date to be fixed by registry.
Always.
May I please your lordship? Lordship, as per office note dated 17/7/24, notice served upon the respondents except respondent number 711 and performer respondent number 1 and 2.
I'm preparing for respondent number 1 to 6, your lordship.
1 to 6?
Yes.
Okay, good. Heard Miss, what is your name?
B. Bora.
Heard Miss B. Bora, learned counsel for the appellant. Also heard Mr.
R.K. Singh, sir.
R.K.
Singh,
appearing for respondent number 1 to 6 on perusal of office note dated. How many respondents are there?
Lordship, 12 respondents.
On perusal of office note dated 17/7/24,
Performer respondents.
it appears that the notices issued to the AD card issued, AD card in respect of the notices issued to respondent number 8 and 12 have been received after who is 8 and 12?
Circle officer, right? Bodoland Territorial Council, your 8 and 9 is settlement
The
officer.
seal of the respondent number 8 and 12. The notices on respondent number 8 and 12 are deemed to be duly served. We have standing counsel of respondent number 8 and 12 in this court.
I don't know.
I don't know, I did not.
BTC.
As regards respondent number 7 and 11 is concerned, are concerned, neither the AD card nor unserved notices have been received back from the said respondent. Hence, the petition appellant is directed to take fresh steps on the said respondents by registered post with AD within a period of 7 days from the date of this order, returnable after 4 weeks. Release this matter after 4 weeks.
Much obliged.
Yes, what is this?
In this case, my lord, interim stay order is there, my lord, in the my execution case, my lord.
Execution case.
Yes, my lord. The second appeal is already admitted in subsequent question of law also framed, my lord. And lower court record also called for, my lord. In the meantime, my lord, the interim stay order, my lord, my learned friend filed an objection, my lord. It is there, my lord. We propose, my lord, this matter we find because issue is very small, my lord. Regarding this, my lord, is passport, my lord. The number, some discrepancy is there, my lord, so they were not allowed, my lord, in one trip, my lord. And accordingly, they filed a money suit, my lord, before the district and session court of Jorhat, my lord. And my lord, it was the expiry order, my lord. So, my lord, now we filed petition money appeal with delay application. It was delay application was, my lord, dismissed, my lord. Accordingly, appeal was dismissed, my lord. So I approached this honorable court in some RSA, my lord, second appeal. We propose my learned friend, my lord, the matter be listed on 27th of coming, my lord, for hearing, my lord, final hearing.
I have no difficulty, but interim stay has been given,
Yeah,
right,
till
in a
that-
money decree.
Yes,
Lordship.
ma'am, till that, my lord.
Lordship,
Money decree, anything has been deposited.
No, not
no
deposited.
deposited, Lordship.
Money decree you have to deposit.
Yes, that
Yes,
is, my lord,
Lordship,
if
that
my
is
lord-
the
my lord-
difficulty, Lordship.
Yes, my lord, if my lord, on 27, my lord, next 27th of August, my lord. Till that, my lord, this, if it is allowed, my lord, if it is, appeal is dismissed, my lord, they will get, my lord, 2 lakhs, some 30,000, my lord. This amount, my lord. So till that, my lord, because it will complete, my lord, this, because that part, my lord, there is also, my lord,
If you
because the
concede, we will fix it on 27.
27 for the entire matter, Lordship.
Records have come.
Not, my lord.
Record is not necessary, that may be recorded because, Lordship, the only delay application has been dismissed, Lordship.
Okay. Oh, delay application has been.
Yes,
Yes, only delay,
But reminder for record was.
yes, yeah, my lord.
Well, if not,
If my learned
if
friend,
not reached, on particular date, that order may not be passed, but if not, we'll.
then Lordship, I am pressing the stay, Lordship. Because otherwise, if we wait for the
No, we are
LCR,
not waiting,
because
my lord.
LCR is not-
My.
Without LCR, you will,
Yes, my lord. Yes,
Yes.
you are ready to hear.
yes. my
Yes.
lord. But
That
that,
may be
but
recorded.
that,
Okay,
the lawyer court record not necessary, that may not be reflected in the order. But we are agree, my lord, will.
That I will reflect. Your,
Yes.
this submission I will.
Yes,
reflect.
Lordship.
Heard Mr. S.K. Mehdi, learned CGC, appearing for the applicant, appearing for the appellant. Also heard Mr. S. Dekar, learned counsel for the respondent. Stop. Both RSA as well as IA, same order. This learned counsel for the parties have submitted that in the interlocutory application, which is connected with this RSA, that is IA Civil 378/2024, an interim stay on execution of the decree has been granted. Learned counsel for the respondent has submitted that though the decree was passed in a money suit
Yes,
and no security has been deposited
yes.
while staying the
Execution process.
execution proceeding, he still concede to, he will not press for vacating the execution, vacating the stay if the matter is finally heard on the next day
Yes.
as proposed by the learned Central Government Council. It appears from record that the reminder for trial court record was issued on last day. However, trial court records have not yet arrived. Issue fresh reminder. However, with a rider that if the LCR, if the trial court record does not arrives by next date fixed, both parties have consented to hear the second appeal in absence of the record as in absence of the trial court record.
Yes.
Stop. Considering the submissions made by the learned counsel for the parties, let this matter be listed on 27/8/2024. Both the parties have consented to the said date. Stop.
Interim order continue.
The interim order shall continue till next day.
Yes. Highly.
Please, your lordship, that this I am for praying for a condonation of delay for filing second appeal, my lord. What the delay is, my lord, 1 to 3 8 days, my lord. There's some more delays, my lord.
More than 5 years.
My lord, that delays, my lord. What happened, that case was, my lord, filed by a committee actually. That due to old age, my lord, that committee was not in a function, and subsequently, my lord, that a new committee formed, and subsequently they have, my lord, initiated. That is why, my lord, that I pray, my lord, that may be taken up in any other date. My lord, I have some judgment also, my lord, because Mr. Lordship may take up this day also. However,
You are not ready with judgments. You want
my lord,
to.
ready, I have taken up the judgment, my lord. I could not go through details with the judgment, my
Mr.
lord.
Bhattacharya,
From-
let him go through the judgments. Let him bring.
Yes,
the-
my lord, I would like to place certain things. I am supporting the pro forma respondent. They have filed a objection.
They have filed objection already.
So
We'll
the-
hear on next date. Let
yes,
him
for
come.
5 years, after 5 years. And there are concurrent judgments in the two courts
Yes,
below.
yes.
So,
And
and
no
they
sub-
have not annexed the medical certificate.
No, we'll hear. Let him come prepared. He's saying that
Yes,
he want
My only
to
thing, my lord,
rely
that
on
if
sons.
I want to argue on that, if there is a merit, my lord, sometimes law court may consider.
Okay. Heard Mr. R. Borua. Heard Mr. What
C.
is your
Goswami.
name? C. Goswami. Learned counsel for the petitioner, applicant / appellant. Also heard Mr. K. Bhattacharjee.
For respondents 1 to 5. He's appealing for the.
Government advocate appearing for respondent number 1 to 5. Also heard Mr. H.P. Gwala
My lord.
appearing for respondent number 6. Learned counsel for the applicant has submitted that he intend to rely on certain authorities in this case. However, he has not gone through the same and needs some time to prepare himself before he makes his submissions. Considering the submissions made by learned counsel, the prayer is allowed. Let this case be listed again after 2 weeks. After 2 weeks on the date to be fixed by registry.
Obliged, my lord.
May I please, your lordship?
Yes.
Lordship, in this matter, we were supposed to file an additional affidavit, which has been filed today, lordship.
It is not on record.
Not on record, lordship.
Okay, let it. Heard Miss. What is
F.
her-
Ahmed.
F. Ahmed, learned counsel for the petitioner. Also heard Miss.
Thus, I am representing Council S. Rahman for all the respondents, 1 to 4, private respondents.
S. Ahmed. Learned counsel appearing for respondent number 1 to 4.
Thus,
This additional affidavit is in respect of what? Not service, some other matter. Learned counsel for the petitioner has submitted that in pursuant to the order dated 24/6/2024, the petitioner has submitted the additional affidavit today in the court, but however, same is not yet tagged with the case record. Stop registry to tag the affidavit, additional affidavit filed by the petitioner along with the case record and list the matter again after a period of 2 weeks from the date of this order on a 2 weeks on a date to be fixed by registry.
Deeply obliged.
As per office note, we took steps, but service report is awaited as regards opposite party number 1. And as regards 2, there is report that postal endorsement, Howley SO, that I could not understand what is reflected. And 3, regarding 3, there is report that 3 has expired. My submission that 3 is not necessary here, he is the driver. So he may be stuck up here, 3. And regarding 2, as address is, there is some problem in address. So we may be allowed to take steps for.
This is interlocutory application for condoning the delay.
No, my lord. Delay condonation, IA was dismissed for default. And this application.
For restoration of that.
Restoration. So 3 may be stuck up, 3 already expired and he is driver. For 2 minutes as address, I think the postal endorsement is Howley SO. I could not understand that. So we will be allowed to take steps to usual process so that service can be called. And 1, it may be awaited.
Heard Mr. What is your name?
K.M. Haloy.
K.M. Haloy, learned counsel for the applicant. From the office note dated 13/8/2024, it appears that notice issued to respondent number 1 has not yet returned. Stop, await further. Notices issued to respondent number 3 has returned with an endorsement, addressee expired, as well as notice issued to respondent number 2 has returned with an endorsement within bracket Howley SO, inverted comma, close. In view of the report, in view of the endorsement on the notices returned, received by the registry, learned counsel for the appellant submits that the respondent number 2, who is the driver of the
No, 3 minutes.
respondent number 3, who is the driver of the vehicle involved in the accident. How driver is not an important factor. Okay. May not be necessary for consideration of the instant interlocutory application, and therefore his name may be strike out. The prayer is allowed. The registry to strike out the name of respondent number 3 from the instant interlocutory application. As regards respondent number 2 is concerned, the petitioner, the applicant shall take fresh steps for issuance of notice on the said respondent by usual mode within 7 days from the date of this order, returnable after 4 weeks. Please accordingly.
Much.
I mean, in this case, I have filed a reply mail against the APD objection.
Then
Regarding item number 43, pleadings are completed and matter will be fixed for hearing, admission hearing. And regarding contempt, we are going to appear, but earlier order 31/7/24, color photographs to be provided to us, but not yet provided.
What was?
I mean, I am providing.
Color photograph.
Yes, color. Yes, I am handling.
Color photographs.
Yes, already.
You have,
I have received.
okay.
Hearing contempt, we file the reply, going to file it. 44.
Heard Mr. R. Majumdar, learned counsel for the appellant.
Contempt he is appearing.
I am confused.
44.
No, 40.
Item number?
44 contempt he is appearing.
No, in 43.
43 I am.
Heard
R.
Mr. R. Majumdar, learned counsel for the appellant. Also heard Mr.
Yes, in
S. Sinha, learned counsel for the respondent. The pleadings are complete in this case. Hence, let this case be listed for hearing on a day.
After 2 weeks, otherwise interim is there.
After 2 weeks. After 2 weeks on a date to be fixed by
Yes.
registry. 43.
Interim shall continue.
The interim shall continue. 40,
44.
44. Heard Mr. A. M. Ahmed, learned counsel for the petitioner. Also heard Mr. S. Sinha, who appears for the contender.
Yes.
You will be filing any objection?
Yes, we filed the reply before the next date fixed, so that both the matter came together.
The petition, the counsel for the contender prays for some time for filing the reply against the petition filed by the petitioner in this case. The prayer is allowed. Let this matter be this. Prayer is allowed. The contender may file reply within 2 weeks from the date of this order. Let this matter be listed again along with FAO number 29/24 after 2 weeks on
Yes,
a
ma'am.
date to be fixed by registry.
Further that, but here also that photograph also not given properly. So.
I can color photo required. Yes, I am giving color.
Learned counsel for the petitioner submits that he will furnish color photographs of the annexures
Yes, in the
within-
context.
in the contempt case within a period of 2 days from the date
Yes.
of this order to the counsel for the respondent contemptor.
Okay.
May it please your lordship. There are three miscellaneous cases filed by me. I am the petitioner in this case, your lordship. I was a defendant in the original title suit and the plaintiff, who is the opposite party number 1 in the present case, had expired. Unfortunately, we cannot contact the counsel even in spite of the fact that my learned friend had filed an IA informing the fact that the opposite party number 1 had expired. So there are three missed cases. Your lordship may kindly peruse my first missed case, IA 2020-2024.
A2020.
This is with respect to the abatement, your lordship. The suit abated against the opposite party number 1. That is why I filed this petition, your lordship. The abatement will be set aside.
It is within the period of limitation.
Your lordship, there is another.
You have any submission?
No, ma'am.
You don't have any objection?
No.
Okay. Yeah, filed within the period of limitation.
No, your lordship, that is why I
How
have
much?
filed another IA 2021-2024, your lordship. That is.
For
there is a
condoning the delay.
There is a delay of 32 days, your lordship. And then IA 2022. Your lordship, that is the IA that I have filed for substituting the legal heirs of opposite party number 1.
In IA 2022. Heard Mr. S. What is Mr. T. Deori, learned counsel for the petitioner applicant. Also heard Mr.
G Imtiaz, my lord.
J. Imtiaz.
G Imtiaz, my lord.
G. Imtiaz appearing for
Respondent 31233.
respondent number 31233. Who expired? Respondent number?
Opposite party number 1, your lordship, Hemendranath Dekar.
This application has been filed under order 22 rule 3 within bracket 2 of the Code of Civil Procedures number 1908, read with section 151 of the said code for setting aside the abatement of appeal on death of the respondent number 1, Hemendranath Dekar. It is submitted by learned counsel for the applicant that the respondent number 1 had expired on which date?
17/11/2023, your lordship.
On 17/11/2023.
Para 6 of my petition, Your Lordship.
However, due to communication gap, the said fact was not known to the counsel for the applicant. And the applicant came to know about the death of the respondent number 1 only on 15/5/2024. And thus there was a delay in filing application for setting aside abatement as well as for substituting the legal heirs of opposite party number 1, late Hemendra Nath Dekar. Learned counsel for the respondent number 3, 1 to 3, 3, who has not opposed the prayer for setting aside the abatement. Stop considering the submissions made by learned counsel for the parties as well as considering the grounds shown in the application, the abatement of the connected regular second appeal number 63/22 against late Hemendra Nath Dekar is hereby set aside. And this interlocutory application is disposed of. Next. Next is 2021. Heard same Mr. T. Devi and J. Imtiaz. This application under Section 5 of the Limitation Act 1963 has been filed for condoning the delay of 32 days in preferring the substitution petition for substituting the legal heirs of Hemendra Nath Dekar, who had expired on 17/11/2023. Learned counsel for the applicant has submitted that by order dated 16/8/2024, that is today, in IA number 2020/2024, the abatement of the connected RSA in respect of late Hemendra Nath Dekar has been set aside. Learned counsel for the petitioner has also submitted that the petitioner was prevented from approaching this court within the period of limitation for substituting the legal heirs of opposite party for reasons mentioned in the paragraph number 7 of this condonation of delay application. Learned counsel for the respondent number 3, 1 to 3, 3 does not oppose the prayer for condoning the delay. Stop. In view of submissions made by learned counsel for the parties as well as reasons shown in paragraph number 6 and 7 of the condonation of delay application, this court is of considered opinion that the petitioner has sufficiently explained the reason for committing the delay in preferring the connected, in filing the substitution petition for substitution of the legal heirs of Hemendra Nath Dekar. Stop. Hence, the delay of 32 days in preferring the substitution petition is hereby condoned. And this interlocutory application is disposed of. Next. 2022. Heard Mr. T. Devi and Mr. G. Imtiaz. This application under Order 22, Rule 3, read with Section 151 of the Code of Civil Procedure, 1908, has been filed by the applicants / appellant for substituting the legal heirs of late Hemendra Nath Deka. That is respondent number 1, who had expired on 17/11/2023. Stop. The learned counsel for respondent has not opposed the prayer for substitution. Considering the grounds mentioned in the substitution application as well as submissions made by learned counsel, the prayer for substitution is allowed. Let the legal heir of late Hemendra Nath Deka, namely Napoleon Deka and Marvelin Deka, be substituted as respondent number 1A and 1B in place of the respondent number 1 in the memo of appeal. The registry to substitute the names of aforementioned legal heirs in pursuant to this order in the memo of appeal within a period of 1 week from the date of this order, and list the regular second appeal again before this court.
I'm deeply obliged, Your Lordship.
Substitution application is hereby disposed of.
Deeply obliged.
May I please, Lordship? Lordship, in the last order, that is on 12/7/24, we were directed to take steps. However, inadvertently, we cannot take steps at which we will be taking in next 3 days. Therefore, it's my humble prayer to your Lordship to kindly grant us 3 days' time to take steps.
Any stay is there?
No, your Lordship.
Stay is not there. Okay. Third, Miss
Armorali on behalf of H. Buraga.
R. Bharat is submitting on behalf of Mr. H. Buraga, learned counsel for the petitioner, has submitted that due to some personal difficulties, the petitioner could not take steps for issuance of notice to the there is a stay. Stay is there. We are vacating this stay. We should not take steps for issuance of notice on the respondent number, on the respondents as directed by this court by order dated 12/7/2024. The considering the submissions made by learned counsel for the petitioner, the prayer is allowed. The petitioners shall take steps within
3 days to 1 week.
3 days from the date of this order, returnable on 31, returnable on 2nd of September 2024. Stop. Though the petitioner is allowed to take fresh steps for the ends of justice, however, as the petitioner has not complied with directions of this court by order dated 12/7/2024. Hence, the interim stay granted to the petitioner by the said order is hereby vacated. Please this case again on 2nd of September.
Highly obliged.
Itu Nepal reserve হয়েছে না interlocutory application তাতে তো staple করে দেব।
May please, Lordship. Lordship, may kindly see order dated 13/10/2020.
50 কি ম্যাম?
13/10/2020.
13?
13/10/2020.
20?
20 years, Lordship. Lordship, permits I'm being
Yes.
Hard CKS Bora, Nana Transport Applicant and Miss M. Patisaji, the Nana Transport Respondent 1 and 2. One, Sri Munia Chauhan, one of the applicants, sworn an affidavit along with a copy of Doni Agro to dated 29/8/2019 in support of fact that notices for the respondent number 329 were published in the said newspaper. On perusal of the same, I am satisfied that a notice was published duly. However, no one has entered defense on behalf of the said respondent numbers 329. Be that as it may, the service of notice on the respondents are deemed to be served. It is further submitted by Mr. Bora that the respondent number 1 had died leaving no heirs. The said fact is supported by Ms. Bhattacharjee, who was represented by the said deceased respondent number 1. Accordingly, as part of submission of Mr. Bora, the name of the respondent number 1 be struck out from the cause list of 2nd April on the date registered to do the needful. The delay condition petition is pending in 2012. As list is made on so and so, on which that the same shall be taken of police disposal. Lordship, we have filed one affidavit reflecting that we have taken newspaper publication for order. Accordingly, it was being served. After doing that, Lordship, the opposite side has informed the court that the parties from 329, all the parties have died. And
Have died.
have died. So it is their verbal submission, Lordship. I have called my client, asked him whether it is, but he has informed me that he has not seen the parties, but he is also not confirmed that they have died or not died. So it is their verbal submission. So if they want to stand by their whatever their submission, then provide us the death certificate. Because we are also not sure whether these persons are died or not. That is the thing. Otherwise, Lordship, the notice were being preserved.
Your Lordship,
No, but 10A says that they will only inform.
Your Lordship, I am appearing on behalf of respondent number 2. Respondent number 1 has been struck off. Moreover, they have filed a title suit. So they have know the full address of the respondent, 3 and 9. And I am not the family members of the 3 and 9.
We have served a notice. Now you are saying that they have died. So provide us something, the death certificate or like that, so that we come to know.
No, what they are required to inform.
For example, the death certificate, Lordship, because I called.
No, whether they are required under law to give that death certificate.
Lordship, it's a matter of right, Lordship.
No, read 10A. Order 22, Rule 10A. You will just inform the court regarding death of the party.
Yes, Lordship.
So they have informed. You have to
They
find.
informed, Lordship.
Moreover,
the nature of informing, Lordship, they have just verbally informed.
Is it on record?
Yes, Lordship.
It is recorded in the
second last order.
It is recorded in the order sheet.
Second last order, Lordship. My brother, Amar Adhikari.
Your Lordship, moreover, they have taken times for obtaining instruction.
That's
On the
fine.
last day, they have not appeared.
The last day, I could not appear because I was not well. Hey, there's something.
Now what do you want?
So,
They cannot be compelled unless they have it.
Thing is that, Lordship, when my client visited my office, Lordship, he's not sure. This is the first thing. Second thing is that lordship,
This is a suit,
right title, interest and declaration person.
so you must be knowing who are threatening you, whether they are alive or different.
In fact, lordship, in this case,
Duty is cast on
yes,
you.
it's because as per my client, lordship, these persons are not. They were made party once upon a time, lordship, in the suit, but they are not directly related with this, because our.
Then you,
Yes.
this is a regular second appeal. Your suit was dismissed. What has happened?
Lordship, the suit. the judgment
Nobody
was
knows
that
this
it-
story.
No, actually, I've come for Indica to this conversation itself. If you lost
No,
lordship,
in regular second appeal, you must know the earlier stories.
yes,
There are two stories.
yes, in that.
Trial
judgment
court as
was
well as
released at
first.
December 33, lordship.
I'm not going through judgment now. You take instructions. Take instructions, whether otherwise suit will abate against those. The appeal will abate against those defendants.
Understand, lordship, but the thing is that, lordship, when my client visited, lordship, he was able to provide me the name of the legal heirs of 3 and 9. He also doesn't know. So,
No, you try to find out whether they, if somebody dies, people in locality comes to know that somebody has died.
from the locality only, he has come to know, he has gathered this those information also.
That whether they have died or not.
Actually, no, say it is from their side that these people has died, not from our side. So actually, they should have assisted us, lordship, in gathering the information.
No, nothing beyond that. They will only inform that they have died. You have to collect. They are not. You take some time and find out. Mr. What is the name?
CKS Bora, lordship.
Mr.
CKS Bora, lordship.
CKS Barua. Learned counsel for the applicant. Also heard Miss M. Bhattacharjee, learned counsel for the
Respondent number 2.
respondent number
2.
2. Do you have the information regarding?
No. About the date, I have already.
No, from where she has
From
got the
where she
information.
came to know?
That is the whole thing.
About the date, I have already informed the court.
From where it came from? But as per this thing was saying, we have already done the newspaper publication and the notice will be served. It was been recorded by the court.
No, but they have died. Now,
It is their personal residence.
now you come to the court with a counter version that you have seen them, they are alive. Because they are defendants. Or you come with the legal heirs of the respondent.
Legal lordship, from respondent number 4 to 9, also we could not gather, lordship.
You take time. Mr. CKS Barua, learned counsel for the petitioner, seeks some more time to gather information regarding the legal heirs of the respondent number 3 to 9, who are reported to be dead by the counsel for respondent number 2, and same has been recorded in order dated 21/11/2022 by this court. The prayer is allowed. Let this matter be listed after 4 weeks.
Master lordship.
Yeah, how much time will you take? 20 minutes only. Then wait for 5 more minutes. Yes, correct. What is this?
Right, please, the lordship. Here, lordship was pleased to grant bail, right, annexure 1, page 11. Lordship, kindly have a look. In page number.
But nobody is there from the
Yes,
NCB.
in the
That is
prosecution, sir.
required. Unless there, it may not, you have to
That is-
notify them.
We have already, Lordship. We have served a copy, Lordship.
Today, you inform them that matter is being taken up today. That
Let it come on Monday, Lordship.
Okay.
And inform them.
heard Mr. S.
A. Bhattacharya.
A. Bhattacharya, learned counsel for the petitioner. No one has appeared for the NCB.
Lordship, it will be, it is not NCB, it is.
No one has
Public
appeared for the state. Let the learned public prosecutor be informed. And let this matter be listed again on Monday.
Monday, Lordship. I will intimate them today itself, Lordship.
That is on 19th of August, 2024.
Definitely.
Lordship, if I may take just a indulgence, because I think a long hearing is going on. Lordship, item 50, Lordship, they have brought it by order. So I could not even mention that, but now he
Item?
says 50 and 51.
My lord, my senior leg in another court, so.
His senior is on leg in another court. That apart, Lordship, in 51, they haven't taken step. They have brought the case for hearing, but in 51, they have to take step. Already that order is there, they haven't taken. Office note is there. So আপনাকে step to লই লব। তারপর hearing ও জানাবো।
Steps for issuance of notice.
Yes, in Lordship will peruse 51, item 51.
Item 51.
They're tagged together, একেলগে বান্ধা আছে।
51 দিয়ক। Heard Mr. What is your name?
A. Malik,
A. Malik appearing for Mr.
A.T. Sarkar,
A.T.
Sarkar,
But A.T. Sarkar, who is in 51?
oh, 51.
You are not there in 51.
In 51, actually, I'm also not there because they haven't taken step. But
Then
they have tagged both the cases and brought them for hearing.
50, 80 Sarkar.
In 50, they have taken and the service is
50 is
complete.
ready
Yes,
for hearing.
yes. And here from the very beginning, they haven't taken step.
51 M.
No, then we will, but it is with regard to same case.
But we cannot appear, Lordship, because
Oh,
we
yes.
are not standing counsel, we are panel advocates.
Yes.
So they have to take step.
In 51, none has appeared for appellant on call. It appears from record that no notices were issued. This is 51.
But they have not taken step, Lordship. Office note says that.
It appears that by order dated 25/11/2019, this court directed issuance of notice on the respondents by registered post with AD as well as by usual mode within 3 days of the date of the order, returnable within 6 weeks. However, it appears from the office note dated 4/2/2020 that no steps for issuance of notice have been taken by. Then how it is made that
I don't know the last order, Lordship.
last order?
Because there is no wakalatnama, nothing. I do not know. There is some slight mistake. I do not know how it happened.
Then, however, on perusal of office note dated 4/2/2020, it appears that no steps have been taken by the appellant for issuance of notice. Stop. It also appears that no wakalatnama for respondent number 1 has been filed in this case by any counsel. Stop. The appellant is directed to take fresh steps for issuance of notice on all the respondents by registered post with ID within 7 days from the date of this order, returnable after 4 weeks. Let this matter be listed again along with MSC case number 514/2019 in orders column.
My lord, date may be fixed.
No date in orders column. Let the note, otherwise we will segregate it.
Lordship.
Otherwise, we will segregate this
Huh.
on next day.
Because otherwise that is for hearing and they are not
yes.
taking step for last.
In 50,
5 years.
50, heard Mr.
Appellate Lordship in that.
Heard Miss R.D. Majumdar, learned counsel for the appellant. Also heard Mr. What is the name?
A Malik.
A Malik. Speak loudly. Say A so
Malik.
that
Jurekwa.
A Malik.
yes. A Malik appearing for respondent number.
Clements. Respondent number
Respondent.
1, 2, 3, Nikki.
क्यों रिकॉर्ड क्यों लो जाए? Respondent number
1, 2, 3. Shamsher Ali and the children. No, 1, 2.
1, 2.
1 and 2.
अब 3 use again because the bape khoi 1, 2.
My 2 years.
1, 2 devta khoi 3.
It appears that this case was tagged with MSC appeal number 592/2024, which has arisen out of the same accident as well as same accidents. Stop. However, as MSC case number 592/19 has been posted for orders after 4 weeks, let this case be also tagged with the same appeal after 4 weeks.
I'll oblige Lordship and thank you Lordship for allowing me in between.
Yes, Mr. Das.
Oh.
First of all, I'd like to distinguish the judgments which my learned friend has referred to. My lord,
Judgments you have taken back or it is there?
no, it is
Judgment below the decision.
4 judgments. He has referred to 4 judgments, my lord. Now,
Copy of judgment. Yes.
yes. Now, regarding my lord, the 2009-14
You
SCC.
refresh me. We have some time.
Yes, ma'am.
Within 5 minutes, you refresh.
Now, what had happened, my lord, I'll refer to as plaintiff and defendant. It will be easier, my lord.
Yes.
My lord, I am the plaintiff out of which suit this second appeal has arisen, my lord. Now, I had filed a suit for declaration of my right title interest and there was a sale deed. Now, my vendor, what he did, after he had sold that land to me in the month of November. In the month of December, he had sold the same plot of land to
Yes.
Mr. Some Kundalias. Then there was, after few days, a rectification deed was executed in favor of those Kundalia brothers. Now, after rectification, the sale deed in respect of Kundalia brothers and it becomes same plot. It cannot be. Now, Kundalia brothers, they have filed a suit for enforcement of their
66.
66 of 94 years. Sale deed. That suit was dismissed. Against that suit, this Kundalia brothers have preferred an appeal dismissed. In the suit of Kundalia brothers, the plaintiff of this suit, this Ramnagina, he was one of the pro forma defendant. Now, Ramnagina had filed a written statement, and in written statement, he has just taken that stand. He have made instead of saying that be dismissed, he has said that
declare his right. So the court,
So they are claiming that they have filed counterclaim.
they have filed counterclaim, but in order to constitute a counterclaim, my lord, your lordship, I have taken your lordship to the records also. There was no date fixed for my lord, WS on counterclaim. There was nothing in the record of 66 of 94 that this Ram Nagina has filed a counterclaim. And if it was a counterclaim, there ought to have been court fees, my lord. Because without paying court fee, the suit cannot proceed. Because counterclaim is akin to suit, my lord. So therefore, my lord, no court fee was paid, my lord. No date was fixed for filing written statement on counterclaim. So therefore, my respectful submission with your lordship is, my lord, that written statement only because of a prayer which was
For declaration of right.
for declaration. So that is not at all a counterclaim, my lord. So those were the issue. Now the issue on which your lordship was
And
here.
their plea was,
Yes, this
as the counterclaim was not disposed of,
section
10 is applicable.
applicable. So now there was also in section 10 application, this subsequent suit was stayed, but ultimately the suit proceeded. Because proceedings, meaning thereby that section 10 was vacated. So if that section 10 was vacated, that was also not challenged. So ultimately the suit proceeded and suit was decreed. Now suit was decreed in this suit, out of which this second appeal has arisen, my lord.
That is 15 of 2007.
Yes, my lord, 15 of 2017.
Yes.
Yes, 2007. my lord. Now, in this case, this appellant herein was the defendant number 1, and the defendant number 1 had allowed to reside the defendant number 2 in a portion of the suit line. So one hand to basically this one is the person who is contesting the suit and appeal. Now, why they have filed a joint written statement. Now, in the joint written statement, I'll just take for refreshing purpose, just for a moment, I will take your lordship.
Okay, he died, Alauddin died.
Yes, Alauddin died. This Kobiraj, Alauddin Hakim.
Hakim
Hakim. So,
died.
Hakim
And there
died.
is no substitution.
There is no substitution.
Therefore, his plea was the suit is entirely abated.
Entirely abated.
Your
Now-
claim is it is partly abated only against the defendant.
Yes, now my argument will be, my lord, even if it is held to be abated, it will be abated against this Hakim, defendant number 2. Now, my lord, the question of abatement was never taken before any of the courts below.
But he died during the pendency of
Now,
the suit.
yes, now in order to, my lord, arrive at a decision regarding abatement, there has to be a date of death.
Okay.
Now, in absence of date of death, my lord, as in the earlier case, your lordship has rightly pointed out that if a, my lord, party plaintiff or defendant, whosoever dies under 10A, the counsel has to inform the court that yes, so and so has died. So he will furnish a death certificate or whatsoever, or he will inform the court. Now, after that is informed, then it is on the adverse party to take steps for substitution of the deceased plaintiff or defendant, whatever may be. Now, here is a case where your lordship will find in the trial court, there is not even a single whisper, because 1 and 2, my lord, same advocate was appearing. This defendant number 1 and 2 was being represented by the same advocate. There is nothing on record. This, my lord, entire case record I have gone it. There is not
No information under 10A.
there no information, nothing regarding the death of 2. Now, in absence of any information being furnished to the court that yes, the defendant number 2 has expired, how, my lord, the question of abatement would have arisen? Even assuming that yes, during the pendency of the suit, 2 has died, my lord. In that case, my lord, when these issues were framed, the defendant number 2 ought to have made a prayer for amendment of issues that yes, the defendant number 2 has expired, legal has not been substituted, so the entire suit abates. So that has also been not done. Now, for the court, let us say that the courts below have erred in passing this judgment without considering the fact that defendant number 2 has expired. Now, if the court has to pass an order that yes, a suit or appeal has abated, my lord, there has to be a date of death, because total days is 150 days, first 90 days, then 60 days. After within 90 days substitution, no substitution abates, then 60 days, my lord, abatement, and that after that section 5, all those things. So in any case, my lord, in order to come to a conclusion regarding abatement, there has to be a date of death. But in neither before the appellate court nor before the trial court, there is not even a single whisper about the date of death or about the death of the defendant. Number two. Now, in the appeal,
When this plea was first taken
in this court, on
in
this question,
RSA,
yes, in RSA.
No, no, my lord.
No, no, yes,
Appeal.
yes, I am taking your, I am
In
taking.
the
it.
first
No, no, I
appeal
have
also
not
taken
taken, page 81.
My lord, suit filed by the plaintiff, he is residing near our residence, he should have the knowledge. Why I
No, no.
furnish him, my lord, he had the knowledge to substitute, my lord. Why I
My lord will
inform him, my
come
lord?
to page 80, my lord.
Not necessary for on my part. He filed a suit.
Page 80 of the memo of appeal, my lord. Now, I'll, page 80, lordship got in, my lord.
page 80.
80. Memo of appeal.
Yes.
Yeah, so my lord, this is the first page. Then lordship will come to page 81, second page. Down below, similarly, lordship got in, my lord. Page 81, similarly. Last line, my lord. Last line, right hand side.
Yes, similarly.
Similarly, defendant number 2, Alauddin Hakim, who was the defendant number 2 in title suit number so and so, contested the suit and filed written statement. He too died during the pendency of the suit, but his heirs were not substituted. Therefore, respondent number 2 and 9 are necessary parties, and in their absence, no effective decree can be passed. As the learned Munsif has passed the judgment, it has become a judgment against 2 dead persons, which is void as per law. Curiously enough, the respondent number 2 cleverly kept himself out of the purview of this court, but his game might be exposed. I don't understand what is this. Now, here in this ground, in the first appellate court, the issue was, which has been raised by the appellant here, in that because of non-substitution of the legal heirs of the respondent, deceased respondent number 2 and 6, the suit is non-bad for non-joinder of necessary parties. They have never raised an issue that the suit or appeal has abated because of non-substitution of the legal heirs of the deceased dependent, my lord. Now, your lordship has seen this is in the, my lord, trial court judgment and trial court record, my lord. I have gone through trial court record orders. There is nothing regarding the date of death, or not even a, my lord, this intimation to the court that the defendant number 2 has expired. Now, who knows, my lord, this may be a game plan of the defendant number 2. Tomorrow, if the defendant number 2, he is alive, we do not know in execution, because your lordship knows, my lord, in order to get a decree executed, this is much more tougher than getting a decree. Now, tomorrow, this may be a game plan of my lord, if he is alive, because there is nothing on record that he has expired, apart from making this bold statement in this memo of appeal that the defendant number 2 has expired. Now, tomorrow, if this man is alive, now we say that this decree has abated, he is dead, my lord. Now, on what basis, my lord? There has to be something on record, my lord.
Who will bring that information, my lord?
No,
It is his duty, my lord.
When he, my lord,
It is his duty.
yes, ma'am.
He should bring that point on record when he died, when he is legally here.
If in
That
this-
point is not cannot rise, my lord.
If you intervene in between,
My lord.
it will spill over to another day.
My lord.
So now, as the council was saying, had it been bona fide, my lord, council was this 1 and 2, same council was representative. Why no intimation was given to the court that 2 has expired? Now coming in appeal and second appeal, taking a state, whether they have let my learned friend show that he has taken this ground of abatement before any of the courts below my.
No, but in appellate court, he took.
He says non-joinder of necessary parties, and the court has dealt with.
But he informs the court that he has died.
No, my lord, where he informs.
In the memo of appeal.
No, in the memo of appeal, my lord, he says that he has died, and because of the non-substitution of the legal heirs of the respondent number 2, it is bad for non-joinder of necessary parties. Now, this is two different things. Non-joinder of necessary parties, court will decide whether he is a necessary party or proper party, then court will proceed. But if the court has to come to a finding, my lord, that yes, the suit has, because of this death, the suit has abated, my lord, then my lord, there has to be a date of death. Otherwise, my lord, from which date the court will say, or court will, my lord, court cannot presume that yes, just because in the memo of appeal it is said, it will abate, my lord. In order to come to a definite finding, my lord, the court has to come to a finding that yes, the person has expired. Now, in that regard, my lord, I would like to refer to a judgment of the Bombay High Court, my lord, because and in this constitutional bench judgment, my lords, it has been now in this case, citation to 2011 0 Supreme 11 0 Supreme Bombay 1534. Now, my lord, 1534. My lord, in this case, this one delay basis substitution application was filed. It was belatedly filed, my lord. Now, in that context, para 10, my lord, that appeal was application was dismissed. Para 10, my lord. In order, lordship got it, no?
Yes.
In order to dismiss the appeal as abated under Order 22, Rule 3, Sub-Rule 2 of the Code of Civil Procedure, the court must record a finding about the exact date of death of the respondent plaintiff. If the fact of death of the party is disputed, then evidence is required to be laid to establish the date of death of the party. It is only upon recording the finding about the date of death of the concerned party that an order of dismissal of appeal as abated can be passed by the court. Now, these are here referred to the facts. Now, para 14, my lord. Once it is held that no order of abatement of appeal could have been passed by the appellate court in absence of finding on the date of death, and no application from bringing the legal heirs of the deceased respondents could be filed in absence of the date of death, the question of delay in filing application for bringing the legal heirs on record and causing delay in setting aside abatement does not arise. So, my lord, in this judgment, my lord, at para 9, the limitations of 90 days and 60 days has also been provided. So, in absence of any, my lord, date of death, the court, my lord, yes, let us say for the sake of argument that he has taken a stand in the memo of appeal that defendant 2 has expired. Now, in order to enable the appellate court to come to a definite finding regarding the day that abatement, that yes, this person has expired on so and so, so suit has abated. So there has to be, my lord, something on record pertaining to the date of death. Now, as there is no date of death, my lord, so therefore, and that ground was never taken before either of the courts, because here he says that he has died during the pendency of the court, pendency of the suit. Now, if this defendant who has died during the pendency of the suit before the delivery of judgment, because between argument and delivery of judgment, if dies, then no abate. So, let us say their story. So, it is before, my lord, argument. So, if it is before argument, why no application was filed for amendment of pleadings? This amendment of issues, my lord, that see 2 has died, 2 legal heirs have not been substituted, 2 has expired. Now, this issue has to be framed. So, that was also not done. So, meaning thereby, my lord, that issue was not raised before the trial court. Now, in the appellate court also, appellate court that say that, my lord, they have raised that issue, trial court have not considered it. Now, before the appellate court, they ought to have raised that issue, but see, this person has died on such and such date and it has not been substituted. So, please decide the issue, because this is, my lord, if that is the crux of the matter. If that is decided, no need not go into all these 64 and all those things, everything goes. So, why that was not issued? Now, here in the ground of appeal, what he says that because of non-substitution of the legal heirs, then it is bad for non-joinder of necessary parties. Now, in the pleadings, my lord, even let us stretch it more further. Let us say that, my lord, yes, defendant number, legal heirs of defendant number 2 were substituted. What better they could have developed this suit? Because what is the pleadings? Pleadings of the defendant number 2 is just 3 lines, that defendant number 1 had allowed to recite the defendant number 2 over that suit length. Nothing more, nothing less. Now, even if they were implemented minor, they could not have developed this case because their pleadings of the predecessor defendant number 2 is that 1 had allowed to remain. So within the campus of that pleadings, my lord, the legal heirs have to defend the case. To what extent they could have developed their defense, my lord. So that also goes, my lord. Now, and another aspect is as because the 2 has allowed to stay 1, because 1 was saying that he has acquired adverse title by way of adverse possession. So he thought that he has become the owner. So he had allowed someone, this defendant number 2, that okay, you recite. Now stay in a portion. Now at best, my lord, if we say that because originally it has come on record that one's predecessor was the lessee in respect of the plot of land. So if 1 is also becomes a lessee, my lord, he becomes a permissive occupier. So once the authority of 1 goes, my lord, 2 also goes. So if we assume that 1 was a tenant or a lessee, in that case, my lord, who is 2? Who is a subtenant or sublessee, or at best, my lord, a licensee? Now, in all these cases, if the authority of 1 goes, the authority of the subtenant, my lord, sublessee or licensee, everything goes. Then, my lord, so in order to arrive at a conclusion regarding, my lord, abatement, my respectful submission is that, my lord, there has to be date of death. In, my lord, absence of any date of death, my lord, there cannot be any abatement. Then, my lord, licensee. Let us say, my lord, for a moment that he is.
No, before that.
Yes.
The second substantial question of law was whether the suit of the plaintiff abated in view of abatement of the suit against defendant number 2.
Yes.
Whether entire suit has been abated.
Now, that is why whether entire suit has been abated. Now, in order to arrive at a, my lord, finding regarding abatement, there has to be a date of death. In absence of date of death, how could the, my lord, trial court, appellate court, or this court come to a finding that yes, the suit has abated? And the issue of abatement having not raised before any of the courts below, whether it can be raised before this court. My lord, in this context, my lord,
no, but one thing you make me clear. Suppose it is not raised.
Yes.
Abatement will operate according to law.
Yes.
So even if there is no order, if it is found that you died on a particular date,
no, that
after lapse of period of 150 days,
yes,
suit will abate against it.
Yes, suit will abate.
So here your submission is as the date of death is not.
Yes, now from because first of all that 150 days has to be counted. Now from which date that 150 days will be counted? Because for the purpose of counting that 150 days, some date has to be there, my lord. From which date that 150 days will be counted? And even, my lord, assuming that yes, this abatement, whether, my lord, though that ground having not been taken before the courts below, whether it can be, my lord, and when it is a disputed, my lord, it can be taken before this court. My lord, Honorable Supreme Court, I am referring to a judgment of 2019 5 SCC number 4. 2019 5 SCC 537.
What it says?
Well, that new ground. Because
in the earlier judgment, you says that
that was
date has to be there.
Yes, date has to be given. In absence of date of death, my lord.
What happens?
In absence of date of death, my lord, how the court will come to a finding that yes, the suit has abated? Because for the purpose of coming to a conclusion or finding regarding, my lord, the abatement, the court has to say that yes, on such and such this person has expired and 150 days has expired. and no substitution has been made, so it.
No,
it-
what will be the effect of not mentioning a date?
My lord, if it is not
It will
mentioned.
not abate.
It, but then, my lord.
In spite of knowing the fact that the
No,
defendant
knowing-
number
no,
two.
That is why knowing the fact means, my lord, from where because, my lord, the fact when any judgment is passed, my lord, the learned court has to confine it to the record of the case, my lord. Now, in the record of the suit, your lordship will find there is nothing regarding the date of, my lord, date or death of the defendant number two. Now, if there is nothing on record, from where the court will import the knowledge that yes, two has expired. In absence of any knowledge, the court cannot, my lord, import its personal knowledge and
No,
say.
though information is there in the memo of appeal.
No, in the memo of appeal, my lord. Now, in the memo of appeal, what
Memo of appeal also, it does not mention about the date.
is mentioned about the date?
It
And
mentions during the pendency of the
during
suit,
yes, during the pendency of the suit, my
but
lord.
at what stage it does not mention.
That date he does not mention. Now, even if, my lord, suppose say during the pendency of the suit, that ground has to be taken, my lord. Because now this has become a disputed question, because only saying that he has expired during the pendency of the court, pendency of the suit. Now, the court, in order to effectively adjudicate upon the matter, the court has to come to a finding. Now, where from the court will come to a finding that, see, this person has expired on such and such. Now, he has not been substituted, so therefore the suit has abated. Now,
So
that,
at that, in this second appellate stage, we cannot go into that question.
no, my lord, my respectful submission is that.
Because the evidence is not there on record.
Not there, and the Supreme Court also in judgment exactly says that thing, my lord. This, my lord, paragraph 21, my lord, this 2019 5 SCC.
What it says?
My lord, it says, my lord, I'll just highlighting the relevant portion, my lord. Para 221. It is marked, my lord. Lordship got it? Paragraph 21. Page 4.
Yes.
Yes. My lord, it says that. This is 1, 2, 3, 4. It has given. Fourth, it is settled law that if the plea is not taken in the pleadings by the parties and no issue on such plea was therefore framed, no finding was recorded either by the trial court or the first appellate court, such plea cannot be allowed to be raised by the party for the first time in third court, whether in appeal, revision, or writ, as the case may be, for want of any factual foundation and finding. Fifth, it is more so when such plea is founded on factual pleadings as requires evidence to prove. That is, it is a mixed question of law and fact and not pure jurisdiction and legal issue requiring no facts to be proved. Now, here is a fact, my lord, regarding death. Now, date of death is not there. Now, in order to ascertain, suppose your lordship holds that the suit has abated, so this second everything goes. Now, in order to come to a definite finding, my lord, there has to be a date of death. In absence of date of death, my lord, they are saying this defendant too has expired, but nothing is on record of the codes below that. Only if in the memo of appeal it is said that he has expired. So therefore, my lord, these are mixed questions.
Unless there is evidence on record.
Evidence, there is no evidence.
Evidence would be required.
Yes, my lord.
And
So
in
those.
the second appellate stage, we cannot go.
Yes, my lord. So my respectful understanding of this judgment is that, my lord, that if those issues are not raised and if the issue which is been raised, if requires to be go into that, my lord, intricacy of facts and requires evidence to be laid to establish those facts, then, my lord, those things should be avoided, my lord.
No, then what would be the finding?
My lord, the finding means, my lord, as there those issues have not been, my lord, taken before, that issue of abatement has not been taken before the learned trial court, and there is no, my lord.
Whether your submission is that as there is no evidence regarding date of death.
Yes,
of-
ma'am.
So in
There is-
second appellate stage.
Yes. That cannot be
That
raised.
cannot be looked into
And in view of nothing.
unless there is an evidence on record.
And as there is no evidence on record, so therefore the judgment suffers from no perversity, my lord. the judgments of the courts below suffers from no perversity.
Okay.
And the question of, that is why, my lord, the question of abatement does not arise, because how, my lord, it will be decision of abatement will arrive at. Because in the first appellate court also, their ground is that because of non-substitution, this is bad for non-joinder of necessary parties. Their ground was not that the suit has abated as a whole. Because in the grounds your lordship will find, I have not found, my lord, that nothing, my lord. So meaning there, my lord, that issue was never raised before any of the courts. The issue regarding abatement was never raised before any of the courts. And suppose impediment, my lord, what development would have made? Only, my lord, his in the written statement, at just these 3 lines, my lord. In the written statement, what is the pleadings, my lord? The pleading of the defendant number 2 is at page, my lord, 77, para 13 of the memo of appeal. It says that it is also admitted that the defendant number 2 came to occupy a part of the suit land as allowed by the defendant number 1.
Page number?
Page number 77 of the memo of appeal. Down below, para 13. Last 3 lines, my lord.
Yes.
So apart from only these 3 lines, there is no pleadings of the defendant number 2. And even assuming, my lord, that defendant number 2 has expired, at best it will not be executed against the defendant number 2. It will be executed against the defendant number 1. Because the lordship has seen defendant number 2, he has only filed a joint written statement with the 1. Apart from that, 2 has not taken any steps. Neither he has assailed any of the orders passed in this case, neither he is a party in any of the context. So, my lord.
Now, suppose the appeal is dismissed.
Yes, my lord.
And decree is going to be executed.
Yes.
When the bailiff goes
Yes.
for executing the decree,
yes.
he finds legal heirs of defendant number 2
It
in
will not be executed, my lord. If they fight, then it will not be executed against the defendant number 2. But is there a bar in executing the decree against the defendant number 1?
Okay, there is no bar.
There is no bar.
Okay.
Because suppose, my lord, let us say, my lord, because I am stretching my argument to the extent possible this way, that way. Let us say that for argument's sake, yes, 2 is there. So if 2 is there, when the bailiff goes with all his armed strong men, he will see that 2 or his legal heirs are there. So he will say, okay, as there is no decree against you, you decide over there, it will be executed against 1.
But for that, the entire suit does not get abated.
Entire suit does
That is
not-
the question.
Yes,
before
my
us.
lord.
Okay.
And my lord, in all probability, keeping those things in mind, this judgment of this 2003, that Amarjit Singh Kalra, which I have referred to, my lord, that is a constitutional bench judgment, my lord. Last date I have given, my lord, 2003 3 SCC 272. This I guess, 2003 3 SCC 272.
Only appellates.
It will be from, my lord, Supreme Today citation. That Amarjit Singh Kalra, 2003 3 SCC.
Yes.
Yes.
Amarjit Singh.
Yes, that is a constitutional bench judgment, my lord.
Para 27.
Yes, my lord. In that case, my lord, suppose in this case, suppose say, my lord, this 1 is there, he is contesting the suit. He had allowed 2 to reside. Now 2 has, my lord, vacated that plot and 2 has gone from there. Now, what will happen in that case? Whether for the act of the 2, the decree will not be executed. Perhaps, my lord, keeping those things in mind, the Supreme Court has made an observation. Suppose during pendency of the suit, suppose a party So there are two, three parties. One of the party compromises the matter with other. Then he is out. Now, once he is settled, he will not come to the litigation. Now, because of the settlement with one party, where the decree cannot be executed against the others. So those things, my lord, the relevant portion, my lord, paragraph, and the court has this, apex court has also said that, my lord, this procedural aspect, my lord, that laws of procedure are meant for advancement of justice, my lord. Paragraph, my lord, 27. Para 27.
Yes.
Yes. Laws of procedure are meant to regulate effectively, assist and aid the object of doing substantial and real justice, and not to foreclose even an adjudication on merits or substantial rights of citizen under personal, property or other laws. Procedure has always been viewed as an handmaid of justice and not meant to hamper the cause of justice or sanctify miscarriage of justice. A careful reading of the provisions contained in Order 22 CPC as well as the subsequent amendments thereto would lend credit and support to the view that they were devised to ensure their continuation and culmination into an effective adjudication and not to retard further progress of the proceedings and thereby non-suit the others. Similarly placed, as long as their distinct and independent rights to property or claim remain intact and not lost forever due to death of one or other in the proceedings. The provision contained in Order 22 are not to be constituted as a rigid matter of principle, but must be viewed as a flexible tool of convenience in administration of justice. Then, my lord, in paragraph, my lord, para 32, my lord. Page 21. Para 32, my lord, last portion, which is at next page, page 22, my lord. It starts from 5th line from top, at times.
Yes.
At times, one or other parties on either side in a litigation involving several claims or more than one pertaining to their individual rights may settle among themselves the dispute to the extent of their share or proportion of rights are concerned and may drop out of contest, bringing even the proceedings to a conclusion so far as they are concerned. If all such move is allowed to boomerang adversely on the rights of the remaining parties, even to contest and have their claims adjudicated upon on merit, it would be a travesty of administration of justice in itself. Now, same thing in this case. Well, two, we don't know whether he is alive or not. He is not, whether he is there or not. Suppose he has vacated that plot of land. So just because one had allowed two to remain and he has vacated, he is no more there. Whether, my lord, the plaintiff will not be able to execute a valid sale deed, which he holds, my lord, against the defendant number one, because one has exhausted all his remedies. He has filed, my lord, claimed adverse possession, that has been nullified. He has filed first appeal, that has also been nullified. Then, my lord, para 34. Even assuming that the decree appealed against or challenged before the higher forum is joint and severable, but to deal with the rights of more than one recognized in law belongs to each one of them on their own and unrelated to others. The proceedings abate in respect of one or more of either of the parties. The courts are not disabled in any manner to proceed with the proceedings insofar as the remaining parties and part of the appeal is concerned. As and when it is found necessary to interfere with the judgment and decree challenged before it, the court can always declare the legal position in general and restrict the ultimate relief to be granted by confirming it to those before the court only, rather than denying the relief to one and all on account of procedural lapse or action or inaction of one or other of the parties before it. Then the next, my lord, as far as possible, this court must always aim to preserve and protect the rights of the parties and extend help to enforce them, rather than deny relief and thereby render the rights themselves to iotize, being basic principles of jurisprudence. Now, my lord, Order 22 Rule 4 says that if the defendant dies not substituted, it will abate against the defendant. So this is, my lord, provisions of CPC. Now, in order to, my lord, come to a finding whether that abatement has actually been affected or not, we have to see, my lord, whether that decree is indivisible or not, whether, meaning thereby that whether there would be two contrary decrees. Suppose my lord, this decree is upheld, order passed the trial courts would be upheld, whether there would be any contrary decree against.
What is meant by contrary decree?
Yes, that, my lord, I'll refer to the judgment which has been referred to my by learned friend, my lord.
We have to continue one more day.
Well, no, I'll just in that judgments.
No, because from tomorrow I am going to outlying bench. So otherwise there will be 15 days delay gap.
Yes.
So I don't want to take this case with me.
Yes.
So on the first day of return, let me fix it. We will start as on 2nd of September or 3rd of September, whenever. Because you will take some time.
No, but my otherwise are this my lord argument is.
And Mr. Ahmed is done with. You have.
Yes. Well, yes. No, I have just, my lord,
refreshing.
I have refreshed my lord's memory, my lord. My lord, otherwise my argument is concluded only.
No, you
joined.
keep the last judgment for next day.
No, I am not, the query which your lordship has put, that what is divisible or not.
Yes.
It says that suppose, my lord, in some of the cases, because
What is meant by contrary decree?
contrary decrees, if there is a decree in favor of one person, my lord, now, my lord, that person has expired. Now, from the proceedings, some proceedings has moved into. Now, if there is likelihood of passing a decree in favor of the appellant who has moved in appeal, and if that order is likely to be in contrast to the other decree which is in favor of the, my lord, deceased person, then, my lord, it says that contrary decrees. It is in the judgment which my learned friend
Judgment
has referred.
Explain.
Yes, it says that because in one in
which judgment?
In judgment, my lord, that respondent to the judgment has been published.
Contrary decree. No, we will start from contrary decree.
Yes,
On the next date.
This is, my lord, in 2019 11 SCC 787. That has been revised by the appellant, my lord.
Okay.
Yes. Now,
Lakshmi.
This is
Sunkara.
Sunkara,
Lakshmi Narasamma.
So and so and so. So time and again, Apex Court has only said that it has to be seen that there is no contrary decrees. So decree which is not divisible means it could be it should be executable against a particular person. Now, in this case, my
Only
lord,
then the suit will abate as well.
yes, my lord. If, my lord, a decree which cannot be executed against a co-defendant or co-plaintiff, only then, my lord, the question of abandonment will come.
Okay.
Now, in this case, what had happened?
No, Mr. Das, wait. Now, I also have some queries.
Okay. Then.
I'll put those queries on next day.
Okay.
Let us continue. When would be convenient?
Well, as per your lordship's convenience, my
Third.
lord, as early as possible. So,
Third.
my lord, we also don't forget it.
Third September.
3rd September.
It is a hearing day.
Hearing
because it is a parted matter, it
Yeah.
will be taken up first.
Yes. 3rd September.
Heard Mr. J. Ahmed, learned counsel for the appellant. Also heard Mr. A. Das, learned counsel for the respondents. The hearing remained inconclusive. Let this appeal be listed again as parted matter on 3rd September 2024 at 2 p.m.
Yes, my lord. It will be convenient.
or at 3:30 p.m.
Let it be 2, my lord. It will spill back to 3.
Okay,
If
at
it
two,
is-
at 2 p.m.
If it is at 3:30, it may not reach. No, no, I have only concluded. I have nothing to, my lord.
Okay,
Whatever his judgment, my lord, my learned friend has referred, I will just.
at 2 p.m. Pratham, your judgment will हम के रखें. Judgment is side is recorded. Okay?
Oblige.
May I please, Lordship.